Allowed.
Yes.
Mistakenly recorded, wrongly recorded state advocate. Wrongly. Petitioner's advocate is recorded. Petitioner's name recorded. But state advocate name is Mohim Chaudhary.
You appeared for the state respondents.
Yes, ma'am. I'm already given sleep. But Steno overlooked that.
10 September. Mohim Chaudhary.
Yes. Yes, ma'am.
Please,
Both are.
tomorrow to be mentioned.
Yes.
Duto.
Corporation.
Yes.
In the online application, but the relating to second SLST 25, but the petitioner could not furnish the information as regards his previous teaching experience. Although petitioner is an assistant teacher serving in classes 9 and 10.
No, examination is also.
No, the
file your
during the vacation,
file it will come accordingly. Sorry, I have allowed everybody's prayer. Right to it. This will not continue.
Yes.
Educated youth, if they make a mistake, even after holding of written examination on 14th, if you come and make a prayer, sorry. And in this, before this court matter comes as per presentation form, please don't mention. What is the urgency?
The ground is that my lord knows better than me that second.
Yes.
My lord knows that second residency matter is pending to the honorable effects court. But my grievance before your lordship, on 30th of August, the list was given of the tainted candidates. On 29, that is one day prior to the publishing of that list, I was marked as tainted in my admission and I was from appearing in the exam. I do not have any grievance. I only want to know that on basis of what grounds and what parameters I have been marked as tainted, because my rank was 11.
So it's not an urgent matter. Written examination is complete.
But
Yes.
to appear to the honorable
Yes. It's not an urgent matter. Let it run in the list. Yes. Wednesday to be mentioned. Yes.
770 of I can see that during the pregnancy of the institution now 18 September last Friday, but the president of the institution data to the PIC petitioner before your lordship are seeking by the in the institution we are seeking appointment of administration. Here some illegal activities of the president now president by the usual data to the PIC on 19 September you were discharged from the PIC post. I have selected another person without any meeting. And I am directly.
The administrator has been appointed.
Yes,
Administrator has been appointed in the school.
that is pending before you.
So who has written letter for appointment of administrator?
We are seeking further for administrator for the appointment of administrator. To that effect, we filed the petition during the pendency of the petition on 18 September last week. The president issued a letter to me. We discharged from the GIC post, and I selected another person without any meeting.
Show me that letter.
Immediately, yesterday I prepared a CAN application challenging the notice. That is the date.
So in the connected writ petition, you have filed this writ petition. That writ petition is appearing at item number
770. With notice I have mentioned this. Can you see the notice?
Wednesday urgent motion.
And I filed the CAN application.
Yes. Canter tag kore daw shon. Yes.
My lord,
Yes.
may I be permitted to for inclusion in the list, my lord?
Writ petition.
Yes, my lord.
Hearing or
It's group 2 matters.
hearing or motion.
It is in the hearing matter, my
When
lord.
the last order was
The last order was posted on 26th of July. It's a changed brief after that.
26 July.
Yes,
What
ma'am.
was the order passed?
The order was passed to issue notice upon the respondents, but the former advocate was someone else.
If
my
this
lord.
matter is taken up, wait. No upgradation, sir.
But it's not appearing in the list, my
So
lord.
what was the direction that I show me?
But it, my lord,
Show me what was the order passed by this court.
not in this court. It was appearing before the Honorable Justice
no,
Om Narayan, my lord.
Unless you inform this court and satisfy that is an motion, court will not include it under the heading motion.
Well, kindly be included in the list.
No. Or every matters cannot be included. If it is at the motion stage, it can be included. If it is hearing stage, then it will come under the heading hearing. At present, court is not including any hearing matters. Yes,
Inclusion in the list, it is in the motion,
motion of which year?
2022. 2022.
So why this matter is pending for such a long time under the heading motion, 2022 motion? Today we are in the month of September 2025. What steps you have taken?
Lordship, I have to talk to the advocate. Who is
Yes.
the advocate on record?
If it is motion, monthly list of December. Yes.
Probably to mention one application. Grateful, Your Lordship. Dismissed for default. Lordship,
When dismissed for default?
Lordship gives me 1 minute.
Whether the matter relates to group 2,
It is a pension matter.
whether it is relates to group 2 under relating to my determination.
Lordship,
When dismissed for default?
Lordship will give me 30 seconds.
এখন ডিটারমিনেশনটা দেখে নেবে যদি ম্যাচ করে তাহলে মান্থলি লিস্ট অফ নভেম্বর আন্ডার দ্য হেডিং অ্যাপ্লিকেশন।
Deeply obliged. Deeply obliged.
It is motion or hearing? Motion. Motion of which year? The similar matters can be disposed of. That does not mean all similar matters to be tagged to be included in the list. What was the last order passed? Another motion means? What mistake occurred? ফাইলটাকে দেখবে তো যদি থাকে তাহলে মান্থলি লিস্ট অফ নভেম্বরে দিয়ে দেবে কি ডিফেক্ট দেখে নেবে। ইয়েস special educator matter, I am not upgrading any matter. Sorry, yes, please call the list. Sorry. Not, I am not upgrading. Other matters mentioned, advocates mentioned. No. Whether they are eligible to participate or not, it's not possible at this stage before commencement of examination. It is to be determined. You file it, it will come under the heading. Yes.
But the same matter, the Madras education already passed the order.
Yes. Please call the list.
Item number 1.
Item number 1, Lordship, I am appearing on behalf of the petitioner, Lordship. Am I audible, Lordship? Am I audible, Lordship? Lordship, I am appearing on behalf of the petitioner, Lordship. Due to some medical emergency, Lordship, I couldn't appear before your Lordships physically. But Lordship, the grievances of the petitioner is that petitioner.
You are not visible.
Lordship, my video is on, but due to some probably some technical issue, Lordship, the video is not running.
Yes. What is the matter?
Lordship, the petitioner seeking some information regarding his candidature for in respect of first SLST 2016, Lordship. But that information was not provided by the respondent authority on the ground that
16.
Yes. Lordship.
Prefer appeal under the Right to Information Act.
Lordship, the authority responded response that is all the data is in the custody of CBI authority. That's why they are not providing, is unable to provide, Lordship. Which is, Lordship, annexed at page 22 in my writ petition.
So data is not available to the commission.
Lordship.
Then
if your Lordship directed,
CBI.
then your Lordship kindly allow me to make representation before the CBI authority, and they will.
For that, no, because CBI is investigating the matter, perhaps in terms of the order of this court.
Lordship.
For how court can permit you, unless until investigation is complete.
2016 process already dismissed হয়ে গিয়ে সব তো cancellation হবে।
And my learned friend has rightly observed that this matter has on a
And entire selection has been set aside.
Lordship, Honorable Apex Court has already intervened in this
What
matter.
means? You participated in first SLST 2016.
Lordship.
and you are selected.
Lordship, that's information is required by the petitioner, Lordship.
So
That
if
is the
the selection process is set aside, what remains?
Lordship. Then Lordship kindly pass necessary order, Lordship, in this regard.
Matter is heard. Where is the affidavit of service? Where is the affidavit? of-
Lordship, it is with me, Lordship, but my learned friend.
Matter is heard in presence of the learned advocates representing the petitioner, state respondents, and West Bengal Central School Service Commission. So, next paragraph, grievance of the petitioner relates to inability of the concerned authority of West Bengal Central School Service Commission to provide certain information concerning first state level selection test 2016 conducted by the West Bengal Central School Service Commission for appointment of teachers in classes 9, 10 and 11, 12.
My lord,
Lordship, upper primary.
my lord, this is the selection of upper primary.
Upper primary.
Lordship.
If this upper
So upper
primary,
primary it is
is-
there, still it is on.
yes. I'm wrong, my lord.
So why it is pending before the CBI? Upper primary matter, it is not pending before.
My lord, I have to take instruction. This letter was issued on, my lord, 26th of June 2025.
And today they are coming.
Yes, my lord.
24th of June 2022 letter.
2022. My lord, it says that, my lord, with reference to your petition dated, my lord, 8th of May 2022 in respect of first SLST 80 2016 for upper primary under RTA Act 2005. This is to inform you that as per the solemn order of Honorable Justice Abhijit Gangopadhyay dated 19th of May 2022, the CBI authority has taken over the possession and control of the room of the office on 19th May 2025. Under the circumstances, this office is not in a position to give any data regarding
So now it is not seized. So give information, take instruction and come back.
Yes,
Issue. Upper primary, right?
এইটার এগেইনস্টে অ্যাপিল হয়েছিল, অ্যাপিলটা তো ডিসমিস করে দিয়েছে। অ্যাপিলে এই অর্ডারটা সেট করে দিয়েছেন, এই অর্ডারটা
Let me dispose it of directing the commission to
that would be better.
provide information.
information.
Matter is heard বললাম, তারপর কি দেখো তো? হ্যাঁ। Now, first state level selection test within bracket 80, close bracket 2016. 2016 লেখো, with the first state level selection test within bracket 80, 2016, within bracket upper primary,
তোর কত দেখা
close bracket,
আছে পেপার?
কি বলে? Conducted by the West Bengal Central School Service Commission. দরকার নেই। Conducted by the West Bengal Central School Service Commission. Stop.
But only one thing may I point out, my lord.
It is submitted on behalf of the petitioner that by sending the letter dated 24th June 2022, information was denied to be provided to the petitioner by the Assistant Secretary and SPIU, West Bengal Central School Service Commission.
এইটা বলে দিচ্ছি।
ওকে কিন্তু জানিয়ে দেওয়ার চান্স পেয়েছি কি পাইনি।
On the plea, একই সঙ্গে, on the plea, CBI took possession and control of the data room of the office on 19th May
কোনটা
2020.
জানিয়ে দিতে পারবি, দ্বিতীয়টা পারবি না।
Stop. Petitioner prays for supply of information due to changed circumstances. Next paragraph. It appears from the submissions made on behalf of the parties that first SLST within bracket 80 close bracket 2016 within bracket upper primary is still continuing and selection process is not complete. Due to changed circumstances, it also, it also found from the submission made on behalf of the parties, on behalf of the respondent authorities, that data room of the Office of West Bengal Central School Service Commission is at present not under possession of CBI authority. So, next paragraph. Therefore, concerned authority of West Bengal Central School Service Commission is directed to provide information as applied and as sought for by the petitioner by submitting application under Right to Information Act 2005 within a period of 4 weeks from the date of communication of the
Well, if he sought for the answer script, production of answer script, well, if it is available,
Why not?
if it is not destroyed,
No, it is not. I am hearing this matter.
2016.
Maybe 16. Upper primary matter still, whether B.Ed qualification will be there or not, still your, that is 10%, relating to 10%, whether the acquisition of B.Ed, acquiring of B.Ed qualification after the cutoff date, whether the candidates will be permitted to would be held eligible to be appointed or not, that is being considered by this court. And still your in connection with 90% vacancies, your counseling is going on.
Yes, my
So
lord.
therefore, what is the question?
My lord, I was there in all these matters.
No, sorry.
My lord, all the papers have already been destroyed. my lord.
No. Where the selection process is not complete, how our papers will be destroyed?
My lord, I have
Still counseling is going on. 8th round of counseling was held on 1st of August 2025.
scan copy must be there.
Keyboard.
Scan copy.
Next paragraph, read petition stands disposed of urgent xerox certificate.
Great.
Item number 2.
Sure, for the secondary.
I am for the school authority. Headmaster of the.
You mentioned speak to her. Intuition করতে হয়।
Ready আছে।
Yes, you are for the first school.
Yes, ma'am.
Dugdia Poltadanga.
Yes, yes. My lord,
Yes,
the
please,
problem is, my lord, I have no intention to withhold, my lord, the service book.
Yes.
Only, my lord, the very first year joining his service in my school. And so though I have joined, my lord, in 2009. 2005, my lord, he has taken leave about, my lord, the 16 days. Well, according to leave rules, my lord, 11 days only will be calculated casual leave. Remaining 5 days do not apply whether this leave will be on medical leave. Medical leave, my lord, will not be granted, my lord, on the first joining, my lord, within academic year. There are only 5 days either unauthorized leave or, my lord, the then managing committee has not approved this. He has to make an application whether these 5 days, my lord, on which head or unauthorized.
Petitioner had leave as per the leave statement. Grant this leave.
Lord, no, 11 leaves, my lord, the days.
Out of 11 days, 6 days.
No, out of 16 days.
Out of 16 days.
11 days has been sanctioned as CL, casual leave.
Casual leave.
5
and
days, my
rest
lord,
of that is special leave granted.
special leave, my lord,
He is not working.
that's true,
He is
my
not
lord,
working in your
because
school.
the then managing board has,
Rules take a decision.
yes, your lordship, your lordship's record that, or he has to make an application. Then the my lord, that will be high.
Make an application.
I have no Indian, sir, immediately.
5 days leave.
5 days, only 5 days.
11.
Yes.
5 days leave is to be regularized.
When-
Why you are coming after such a long time? 2021, you have left the school.
And TF has been transferred.
November 2021. What you are doing for last 5 years?
21 I was transferred. 25.
Yes, after 4 years you are coming. Why?
Somebody kept on writing, but
Repeatedly, I requested him.
How many letters you have sent? Show me. Kept on writing.
one in 2023 and one in 2025. My lord, only thing
So you are not serious about pursuing your remedy.
this service
4 years, how many letters you have sent? Show me.
send one
And on how many occasions you have attended this school? First school for regularizing the leave.
that is a problem on my but only thing my lord, the duties order says
They are not at all interested. It goes to show.
because the service
All on a suddenly you have woke up from slumber and filed this writ petition in one fine morning.
I was released with no allegation.
Yes, that is not the allegation. That is only a sanctioning of leave. That is not the allegation against
You
him.
make a prayer
Yes.
for sanctioning leave of 5 days.
5
Tell
days.
me the date.
Date, my lord,
Which are those dates?
Yes,
For
sir.
which period?
my lord, the
For which period? 20?
26th August 2005, very
For
day,
which year?
2005. On that very academic year, my lord, in his service, first joining. Regular, my lord, he taken leave 26, 29, 28, 13 December,
Which
25.
DI? It is under which DI?
My lord, not 24 Parganas.
So service book is still lying with the school, previous school.
Immediately I will send it. Only, my lord, this dispute the 5 days. Other leaves also, my lord, the though has not been sanctioned.
You make an application for sanction of leave to the school authority, and school authority on taking necessary steps shall forward the papers to the whether there was a change of district.
Change of additional district instructor schools within the district of not 24 Parganas.
So the
Different area.
under which DI? Barasat.
Different districts, my lord, not 24 Parganas.
Now Barakpur.
Now.
So therefore, I will direct the DI to you will forward it to the DI Barasat, and we are Barasat will forward it. And the DI Barasat will be directed to whether DI Barasat is a party. And
Barakpur is a party.
what Barakpur will do?
I have made a representation.
What your grievance is against the school? Which school is under DI Barasat? No. You add the DI Barasat, come back. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. District Inspector of Schools AC Barasat and North 24 Parganas has not been added as party respondent. Stop. Next paragraph. Leave is granted to the learned advocate for the petitioner to amend the cost title in courts of this day and array District Inspector of Schools AC Barasat, North 24 Parganas as additional respondent. Stop. However, service of notice upon additional respondents stands dispensed with since state respondents are represented by learned advocate. Next paragraph. Learned advocate for the state respondents is directed to obtain instruction. Next paragraph. In the meantime, a petitioner shall also be at leave to make an application for sanction of leave of 5 days.
5 days.
For the year 2005 before the you are representing head of the institution.
Headmaster of the school, that school.
Before the
9.
Headmaster of Dugdia Poltadanga High School within bracket HS close bracket North 24 Parganas being respondent number 9. Stop. If such application is made, respondent number 9 shall take steps on the said leave application. Immediately thereafter, stop. A report is to be filed by the respondent number 9 on the next day. Next paragraph, list the matter under the same heading for further consideration on 17th November 2020. Next. The client advocate representing the state respondents is directed to obtain instruction from the district inspector of schools. No, from the additional respondent. Next.
এটা অ্যামেন্ডমেন্টটা করে যাবে আইটেম নাম্বার 3
তাই কি বলেছি এটা তাহলে এটা নিশ্চয় দরকার client advocate for the state respondent is directed to obtain instructions from additional respondent. Yes.
Although his name service and coming after prolonged days, the issue was pending as regards the higher pay scale. Now, in 2005 or 2002, I completed. Thereafter, it was forwarded before the authority.
To retire.
Now, in 2006, the Commissioner of School Education books are required regarding institutes. All queries have been made by the school authority.
Whether you have obtained the qualification through correspondence course. Where you have taken admission in the study center at Kolkata or in the main where you have stated where you have stated in the writ petition.
This point was not raised by anybody. To show your lordship.
No, the court is raising this point.
That if your lordship read this, I can file a supplementary.
Court is raising this point.
This which your lordship required that came in to show you 2002 and
Which judgment?
he completed. With your lordship's whose judgment possibly your lordship's relied whether there are study centers.
Professor Yashpal, 2005. 2005.
Yes, 2002 it was.
Maybe.
Anyhow, that was not the issue. Your lordship kindly have a look to this query of the
No, court is asking you. Forget about this query.
No, your lordship.
Mr. Bari, how your qualification can be considered as a valid qualification? Since you have obtained qualification from Guru Ghasidas University, Bilaspur, it is at Raipur, Chhattisgarh. I am telling you, it is affiliated university.
Yes.
But if you have taken admission in a franchisee or a study center at Kolkata, you have your qualification has to be considered.
Neither I have said the question is not there.
Sure. Affidavit of service filed on behalf of the petitioner is taken on record. Any decision is taken by the authority?
No.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner has prayed for sanction of postgraduate scale of pay from acquiring qualification from Guru Ghasidas University, Bilaspur within bracket Chhattisgarh. It is also submitted that petitioner obtained higher qualification, postgraduate qualification through correspondence course. Stop. Next, for a question arises for consideration whether petitioner took admission in main campus at Bilaspur in Chhattisgarh or at a study center at Kolkata. Stop. To that extent, no averment is made in the writ petition. Next paragraph. Whether postgraduate qualification. Next paragraph. Whether postgraduate qualification obtained by the petitioner is a valid one or not, it needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed 4 weeks after ensuing puja vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the bench having determination. Or petitioner shall be at liberty to mention the matter for expeditious hearing after the time fixed herein above for exchanging affidavits. Next paragraph. Client advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days by 7 days after ensuing puja vacation and file further affidavit of service on the next day. Next.
Your lordship permitted to file a supplementary.
No, file your affidavit. No.
আইটেম নাম্বার 4
I request,
Yes.
I request not to do the CDs.
Who is your senior? Cynthia Bala. He has come to court.
Yes, Your Lordship.
He very well not today. What is the matter about Mr. Chakrabarty?
Guest teachers, my lord. Guest teachers, they are asking,
I have fixed.
yes, 11th.
Similar matters are kept on 11th November. I request that you keep this.
Yes, yes. Let it go on 11. Now you take instruction. And I have directed Mr. Boisho to produce the judgment of Justice Mantha. Very well. At the time of call, yes, file your affidavit service. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Matter relates to grant of certain benefits to the petitioner being guest teacher. Stop. State respondents are represented by learned additional government pleader, who is requested to obtain instructions and produce judgments, relevant judgments, and produce judgments delivered by coordinate benches. And produce relevant judgments delivered by coordinate benches. Next paragraph, list the matter. When matter fixed
11th November.
list the matter under the heading, under the same heading on 11th November 2025 for further consideration. Next.
Item number 5.
The petitioner participated in the upper primary, but he could not join
Yes.
the prayer for extension of recommendation. Admittedly beyond 90 days, but within
Ill. Petitioner was ill.
father was unwell,
Father was ill.
and I candidly submit. he was
Mr. Lahiri, how I can pass this order?
Your lordship
Because
has,
I have already disallowed others.
lordship has,
Only I have passed an order in a case, in those cases where candidates have lost job.
for non-job loser also lordship passed on.
Yes, that is in case of the petitioner, that is that matter.
Yes, yes.
That is in
My
case of the petitioner where petitioner had
Medical
undergone
surgery.
surgery.
Only one humble submission before your lordship, my lord. The school is still vacant. They have written to the commission that you can send him. There is a vacancy. I have given this document. And
Since
second,
I have taken a decision in
I
terms
understand the
of
predicament of the court.
17.3
I understand.
that after expiry of 90 days, this recommendation does not remain alive.
Absolutely.
So if this is my view, how I
I
can
understand the predicament
dilute
of the
this
court.
view?
Only one humble submission before lord.
Try to
Understand.
appreciate.
I understand, my lord. Only one humble submission.
Because
Have-
primary teachers are coming
Absolutely.
in anticipation of losing job
Losing.
or in apprehension of losing job.
Yes, yes.
That and they are also coming that allow us direct the authority commission to consider our representation.
Man-
That we this court is
Is not allowing.
is
I know,
allowed.
but only one humble submission, then I leave it to your lordship, my lord. 117.3 says 150 days. If he makes application, it may or may not be allowed by the commission, subject to the discretion of the commission. I have no right. I submit before your lordship. I have no right. So if I can take that chance of exercising their discretion, on that ground, I am making prayer, one. And secondly, my lord, I have got the documents. I have annexed also. After 150 days, candidates have been allowed. After, I'm not saying perpetuity of illegality. I'm not.
No,
going into
if
that.
anybody is wrongly allowed.
No, I'm not praying that. Perpetual.
No, not
illegal-
perpetual. If anybody is wrongly allowed.
Yes.
Now,
I cannot
whether
claim
that
it.
can
I cannot.
confer
I
any
cannot.
right.
No. I'm just saying, my lord, there are examples. My submission totally on 17.3. 17.3 does not cast an absolute bar. It says the commission has the. Well, I've annexed the notification. That is, it says commission may. So, my lord, if at least I get the chance to.
Recommendation letter shall remain valid for a period
Yes,
of 90
yes,
days.
kindly take 17.
So what prevented you to make application within a period of 90
Yes,
days?
I could not. I surrendered before your lordship.
Yes, sure.
Kindly take 17.3 for once. Kindly for once. I request your lordship. For once. There is a clause that it may consider merit. I am only seeking. They can reject.
Provided that a regional commission, if it
Yes.
thinks expedient to extend the validity of recommendation beyond the period of 90 days for any reason, a reasonable cause, for the reasons to be recorded in writing, extend the period of validity.
Yes.
When extension of period comes during the lifetime of this recommendation.
90 days. Yes. But
Suppose in a school, managing committee is functioning. We all know that under statutory period is 3. If after expiry of 3 years, when the managing committee has become defunct or it becomes defunct, will the managing committee make a prayer?
functus office should become.
Same thing.
So,
Your recommendation becomes inoperative
after 90 days.
after 90 days. If it would have been filed prior to 90
Prior
days,
to 90
I am passing orders.
Yes, yes. So I leave it to your lordship. I had reasons, man. I leave it to your lordship.
And I am passing orders even after expiry of 90 days in a circumstances where candidates have lost job.
Job
Under the
losers.
special
Yes,
circumstances.
yes, madam, I'm
job
not a
losers.
job loser.
It is not a case of
I'm
job
not a job
losers.
loser. I'm not a job loser. That is the case, madam. I was
Because
only,
your ground is that
my father was on.
that father was ill.
Yes.
So what prevented you to make an application within 90?
Look, kindly see 17 says two ways to see it. Whether I had made application within 90 days saying that kindly extend it, or after expiry of 90 days, whether I can say that kindly extend it up to one, because 150 is the outer limit.
If anybody make an application after 6 months,
No,
what
no,
will happen?
not 6 months.
No, no, I am giving you a flat
no-
example,
I have no right.
a crude example.
I have no right.
What will happen?
I have no right.
Why not? If I accept your contention, then even after 6 months it can be done.
150 days, the outer limit, I have come within the outer limit. That is my-
90 days is the validity period. Within that time, it has to be application has to be made.
then
Well,
wha-
my lord,
I possess
commission so
procedure-
moto can extend up to 150 days.
That is why
Not beyond that. In the present case, my lord, they have made an application beyond 90 days.
but within 150 days.
Maybe. My lord, now, my lord, 150 days has already been over.
So I had made the application
No,
pending.
application was within 150 days.
Within one.
With your case, then I will record it.
No, my lord.
That up to 150 days, your recommendation remains valid.
No, my lord. 90 days, which may be extended up to further 60
If you
days.
say that 150 up to 150
No,
days,
my lord.
anything can be done,
No, my lord.
then why petitioner will be pitted
No,
against
my lord.
order?
This is
So
not.
why you are making such submission?
Lord, I am making the submission for that
It
reason.
is still vacant. That is my concern.
Affidavit of service, last occasion you filed it. But no order, affidavit of service
No, I
filed on
just
behalf of the
handed it to
petitioner is taken on record. Next paragraph. Petitioner was recommended by the West Bengal Central School Service Commission, with a memo dated 19 December 2024, for being appointed, on being selected in first state level selection test 2016 within bracket, upper primary, close bracket. Recommendation memo was issued on 19 December 2024 by the chairman West Bengal Central School Service Commission, thereby permitting the petitioner to participate in a government aided secondary school. Stop. Petitioner did not, thereby permitting the petitioner, thereby permitting the petitioner to join the post of assistant teacher in a government aided, secondary school for upper primary level of class. Stop. Petitioner chose not to join the post of assistant teacher within the stipulated time, and subsequently made an application for extension of validity of a recommendation dated 19 December 2024 with a email letter dated 31st March 2025. Stop. Next paragraph. Learned advocate representing the petitioner relies upon proviso to rule 17(3) of the West Bengal School Service Commission within bracket general transfer, transfer on special grounds and reallocation, close bracket, rules, 2015. Stop. According to the petitioner, in terms of proviso to rule 17(3), petitioner's application seeking extension of validity of recommendation is required to be considered by the concerned authority of the West Bengal Central School Service Commission, and commission should explore the possibility of permitting the petitioner to join the post of assistant teacher by extending the validity of said recommendation dated 19 December 2023. Reliance is placed on an order passed by this court on 28 August 2025, passed on a writ petition being WPA 17247 of 2025 within bracket Shrestha Sen versus State of West Bengal and others. Next paragraph, learned advocate representing commission or West Bengal Central School Service Commission, hereinafter referred to as commission, close bracket, has opposed this writ petition or has opposed the prayer of the petitioner, on the strength of Rule 17 of the said rules of 2016. We opere ওটা said rules of 2016. Of the said rules of 2016. Rule 17 of the Rule 17(3) of the said rules of 2016. It is submitted that after expiry of 90 days, life of the recommendation expires, and if application for extension of validity of recommendation is preferred after expiry of 90 days, same may not be considered by the concerned authority of the commission. Next paragraph. State respondents are also represented by learned advocate. Next paragraph. Next paragraph. Petitioner has attempted to make out a case that father of the petitioner was ill. As a result whereof, petitioner could not join the recommended post in terms of memo dated 19 December 2024. However, on perusing the medical documents annexed to this writ petition, it does not appear that father of the petitioner was seriously ill, for which petitioner was prevented from making an application for extension of validity of recommendation within the period of 90 days from the date of issuance of a recommendation memo dated 19 December 2024. Stop. Petitioner. Now, stop. 90 days expired on 18th March 2024, whereas online application, whereas application seeking extension of validity of recommendation was submitted by email on 31st March 2025. When recommendation memo dated 19 December 2024 was not alive in terms of Rule 17(3) of the said rules of 2016. Next paragraph. Order passed by this court in Shrestha Sen Supra does not come in aid of the petitioner, since in that case, under special circumstances, the court had to pass an order for consideration of application for extension of validity of recommendation, since the candidate who was recommended, since the petitioner who was recommended for being appointed had undergone surgery. Stop. In the present case, father of the petitioner was indisposed, but that was not serious, and which prevented the petitioner to make an application for extension of validity of recommendation within the lifetime of recommendation dated 90 days, if period is reckoned from 19 December 2020. Next paragraph. Extension of validity of recommendation for a period of 60 days is provided under proviso to Rule 17(3), which comes into play if recommendation is alive, not otherwise. Next paragraph. In view of aforesaid situation, no relief can be granted to the petitioner at this stage. Stop. Writ petition stands dismissed. Urgent general service.
Grateful to Lordship. Much obliged.
Next.
Item number 6.
Petition on this matter, my only prayer at this stage is for consideration of my representation by the Commissioner of School Education. Why? My lord, I was appointed in a primary school, then I joined the upper primary school, by which my salary gets reduced. Because of my prolonged period, the primary, my salary got reduced. Now, my lord, there's provision in law, and the government has also accepted that you will be get the continuity of service and pay protection in case that you are attending in higher.
Now you are working in upper primary.
Upper primary. I was in primary. My salary got reduced because I rendered prolonged service in primary. So for that, there is a provision of law. Accordingly, I have made application before the commissioner for consideration. I am praying for consideration.
Where is the
yes? Kindly come to page 50. That is the information provided by the government. By way of
come to the 51.
Yes, may I just kindly see, I need to satisfy your lordship. This is through RTA, government has given this response. Kindly see the tabulation, left hand side, the query. According is that
Yes, it is allowed.
Yes.
It was some third party. So third person lost this query with the information. Kindly take page 50.
But it says that in the second column
Yes.
that the pay protection is allowed, and as per DCRB scheme 1981,
It will be allowed.
that pay protection is allowed. Come to page 50.
Yes, yes. In terms of order period number such and such, pay protection is allowed as per DCL. Protection is allowed in terms of DCL. That's what the. So it is permissible. What I am claiming is permissible.
But the query is according to the present service rule and government order, whether a teacher of a government aided and government sponsored primary schools appointed so and so in junior schools to be allowed for pay protection or not.
So government says yes, it is allowed in terms of DCL.
DCRB scheme 1981.
It can be allowed. Then kindly take page 51 for once. There is a provision for
Page 51.
51. There is a provision for case-to-case consideration.
With reference to subject.
Case-to-case basis, it can be considered by the department. So
What is the date of this document at page 50?
50 is page
1st August 2019.
24
No.
February 2025 this candidate received page 49. That is the covering letter. Page 49 is the covering letter for which it has come, has been informed by the legal purpose.
So is there any difficulty in considering the case?
No, no, next page, page 51. That is Deputy Secretary.
Case basis.
On that basis, the Lordship can refer the matter to the.
Yes, that is what court is
Yes.
contemplating.
Yes.
Let the director of Commission of School Education take.
No. Either the Deputy Secretary wrote to the Deputy Director. So Deputy Secretary is the appropriate authority. He has given the reply to the RTI.
No, he may have given a reply to the RTI, but I will direct the Commissioner of School Division to take.
Here,
Why Deputy Director?
why here, Deputy Secretary written
That
to
will be taken care of by the Commissioner.
the Deputy Secretary written letter to the Deputy
Where is your
Commissioner.
representative? Either Commissioner or the Secretary of the School Education. No Deputy Director, Assistant Director. Yes. 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 Representation.
And there is a provision.
Page 35. He should be granted pay protection.
Yes. Statute provides that.
Where, when it was received?
It was received on dated 28th of April. It was received on.
I do not entertain if a candidate is coming in anticipation that he will or she will suffer loss of salary to the certain extent, but when say a petitioner has joined
Yes.
and not and getting less pay, then pay protection should
Outwardly
be allowed.
long.
Where, when it was received by the,
2nd of May 2025.
where from you are getting this?
Kindly come to page 39. Kindly come to page 39. Can you see the at the top the postal receipt, Commissioner Bikash Bhavan?
Very well, Mr. Chattopadhyay, I am directing the commissioner to take. And he will consider the this notification,
My lord, there are other 3 notifications.
this notification or relevant notification, he will rely upon.
Yes.
Affidavit of,
Granted so that I can place this notification.
yes, yes. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner was upper primary.
Join upper primary.
A petitioner was a primary teacher. Petitioner was a primary teacher and was working in a government aided recognized primary school prior to joining the post of assistant teacher in a government aided secondary school for upper primary section. Stop. Learned advocate representing the petitioner submits that petitioner was selected in first state level selection test 2016 within bracket 80 close bracket upper primary and was recommended for a post of assistant teacher in a secondary school for upper primary level of classes. Stop. Petitioner joined the post and petitioner joined the post in a secondary joined the post of assistant teacher in a secondary school and discharging duty. Stop. Grievance of the petitioner is after joining the post of assistant teacher in secondary school, he is receiving salary less than the salary which he was receiving as a primary teacher. Stop. Petitioner prays for pay protection.
As well as
Taking
continuity of
note
service.
of petitioner's previous service rendered as primary teacher. Next paragraph. Petitioner made a representation dated 28 April 2025 to the Commissioner of School Education West Bengal, being respondent number 2, seeking pay protection. Stop. State respondents,
Continuity of service. Both are integrated.
state respondents and West Bengal, which council?
Howrah District Primary School.
State respondents and Howrah District Primary School Council are represented by learned advocates. Stop. Next paragraph. On hearing the learned advocates representing the parties, it appears that the issue needs to be considered by the Commissioner of School Education. Stop. Respondent number 2 is directed to decide, directed to take decision on representation of the petitioner dated 28 April 2025 by 12 weeks from the date of communication of the communication of this order after granting opportunity of hearing to the petitioner or his representative. Stop. Respondent number 2 shall pass a reasoned order and same shall be communicated to the petitioner by same shall be communicated to the petitioner by fortnight thereafter. Next paragraph. Leave is granted to the petitioner to rely upon relevant government notifications in support of claim of in support of petitioner's claim, whereby in support of petitioner's claim of pay protection and continuity in service before the respondent number 2. Stop. Next paragraph. Writ petition stands disposed of. Urgent xerox of your report.
Grateful to your lordship.
Next.
Item number 7.
The petitioner. My lord, kindly come to page number 32. Medical ground application pending at the end of the commission. Due to temporary suspension of portal, it has not yet been considered. Page 32. 32.
application dated 16th of August 2021.
Transfer on, application for transfer on what ground?
Self-medical.
But it is the application for transfer on physical disability.
Physical disability, not self-medical.
No, yes, physical disability 40% when their provision was there.
Person is not now.
No, that is previously after my application, then 60, it has enhanced to 60%.
But on
It was
December
previously on 40%.
2021, 40% has been enhanced to 60%.
22nd
December
2021.
2021.
Mine was 16th of August 2021. So disability was enhanced subsequently.
Then how you are eligible?
Retrospective effect cannot be given to the notification. And on the date of forwarding, my lord, the notification had not come. If the commission had decided it then, my lord, I would not have suffered this. That is my case.
Why you have not challenged this?
I am challenging this.
2000 maintainability also, my lord, I am raising. On the
Delay,
ground of
delay
delay.
point is there.
2021.
Because, my lord, the portal is suspended and pending for consideration.
To a 31st August 2021.
Yes, my
And
lord.
the application dated 16th August
By
2021.
that time,
What you are doing for last 4
because,
years?
my lord, this portal is
More than
extended.
4 years have
No,
passed in the meantime.
portal is extended 6 months, your lordship knows. So I was
That is not a ground, Mr. Lahiri.
I was waiting for consideration of
How long you wait for another 10 years?
No, it has not been
Yes.
extended for. My lord, kindly see, my lord, is a disabled candidate at that point of
Now it is more than 50%.
60%. I had made on 40%, which was allowed.
Turns to page
Yes,
63.
my lord, only one thing I have to submit. That is, if they had decided on that 2021, it came.
Where is that notification?
Yes.
Page 63.
63. But
Better, Mr. Lahiri, withdraw this writ petition, file an application afresh.
I will not be covered because 60%.
Now it is, you are 40%.
40%. I will not be covered.
Just 40%.
Just 40%. My lord, kindly appreciates. Portal was suspended on 22nd September 2022. They kept it for 1 year pending. Had they decided it, I would have been allowed. I'm a disabled candidate. It's my humble prayer before your lordship.
Where is the original
That is at
first provision of 40%
September.
parent provision?
Page 50. D. Relevant portion. Physical disablement of 40%.
Prior to that, what was the position?
40%.
Before 8 September 2021?
40%.
40%.
2015 original rules
40%.
40%.
In 8 September 2021, it was 40%.
40%.
40%. Subsequently, it was
December 20.
amended and it was enhanced to 40 to 60%.
That is 21st December 2021. Yes.
Commission is, if they had decided it, my lord, I would have got it.
Affidavit of file is
Retrospectivity
filed on
is
behalf of the
not
petitioner
accurate.
is taken on record. Stop. Petitioner made an application for transfer on
16th August.
portal on 16th August 2021. on the ground of disability, as petitioner was suffering from 40% disability. 40%. Stop. It is submitted by the lawyer in reference to based on government based on notification dated 8 September 2021 that an applicant teacher if suffers from 40% disability or more was entitled to apply for transfer top petitioner made application for transfer on 16th August 2021. Therefore, transfer application of the petitioner was required to be considered in terms of the parameters as laid down in notification dated 8 September 2021, not based on the yardstick as contained in subsequent notification dated 21st December 2020. Next paragraph. State respondents and West Bengal Central School Service Commission are represented by learned advocate. Stop. It is submitted on behalf of the commission that due to issuance of notification dated 21st December 2021, petitioner is not eligible to be considered for appointment on the ground of disability, as extent of disability of applicant teacher was enhanced from 40% to 60% or more. Stop. Next paragraph. Petitioner applied for transfer on 16th August 2021 when applicant teacher could prefer application for transfer if said teacher suffers from 40% disability or more. Stop. Transfer application was processed and sent to the West Bengal Central School Service Commission on 31st August 2021. But it was not considered by the concerned authority of West Bengal Central School Service Commission. Stop. Subsequently, extent of disability of applicant teacher was enhanced from 40% to 60% or more vide notification dated 8 September 2021.
Oh, 22nd December.
8 vide notification dated 21st December 2020 as provided under Rule 2 of said note, as provided under Rule 2, whereby Rule 4B was amended. Next paragraph. The notification dated 21st December 2021 does not have retroactive operation. And from the facts of the case, it appears that the transfer application through portal reached West Bengal Central Schools, reached Commission on 31st August 2021, when prescribed criteria for a teacher seeking transfer on the ground of disability was 40% or more. Stop. It is submitted by the learned. It is stop. It is not a case that the applicant teacher was not suffering from disability of 40%. Stop. Next paragraph. In view of aforesaid consideration, have you made Secretariat party?
Secretary, my lord. No.
Very well. In view of aforesaid consideration,
Very
Chairman
granted.
West Bengal Central School Service Commission, being response number 4, is directed to decide transfer application of the petitioner in accordance with law by 6 weeks from the date of communication of this order. And the decision to be communicated to the petitioner by 10 days thereafter. Writ petition stands disposed of urgent.
Grateful, your lordship. Much obliged.
It reached commission prior to that.
Grateful, my lord. Extremely grateful.
Item number 8.
No Passover. Not after at the time of call. Accommodation. You will do the matter. Yes.
But deficit code fee deposit. Matters more relating to the manner the petitioners are. They apply for the post of agronom. For minor acceptance of current subject for at postgraduate level. The kind is 87 minor. And for the post of agronom.
Yes, page 87.
Agronomy subject minor.
Yes.
Page 87 minor.
Acceptance of
Serial number 2.
subjects plus yes, agronomy.
Agronomy minor. Equivalent subject with post-graduation level, MSc in agriculture with agronomy. But minor MSc agriculture. It is branches minor. Minor, as we are appealing that if minor at the time succeed minor at the time of document verification, if they are restricted with agronomy.
At this stage, where is the cause of action? The premature writ petition. You are apprehending what representation? If you are not you participated, petitioners participated as a candidate of agronomy, not as a candidate of MSc in agriculture with agronomy.
MSc in agriculture, not with
So petitioners are MSc in agriculture, not agronomy.
not agronomy.
So you may be prevented from participating in further round of selection process at the time of document verification. But agriculture was one of the subject. If you have any grievance at the time of document verification, then you have to file it. It's a premature writ petition. What is the cause of action? You participated. Examination was held on 14 September 2025. Now thereafter, if you are selected, then question of document verification will come. If you do not come within the zone of consideration, document verification will not arise. Yes. Better you withdraw the writ petition, file it at the appropriate stage. If you are agreed. Yes. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. During course of hearing, learned advocate representing the petitioner prays for leave to withdraw the writ petition with liberty to file afresh. No, withdraw the writ petition. Stop. Next paragraph. State respondents and West Bengal Central School Service Commission are represented by. Oh. State
Commission, it has not been served. I took the
State
instruction.
respondents are represented by learned advocate. And next paragraph. In view of the submission made on behalf of the petitioner, writ petition stands dismissed as withdrawn. However, this order shall not preclude the petitioner to take steps in accordance with law in future if petitioner is aggrieved in connection with second state level selection test 2025. Parties to act on the server.
Item number 9.
I'm for the state, that is headmistress of this. I am for the statement.
And he was appointed in the state and was more than 20 years. And she is the senior most teacher. There is a notification or appointment of assistant.
You are for the headmistress, school authority.
I'm for the.
You are for the state.
I'm for the state.
Please, what you are praying for?
Well, I appeared in the interview.
When interview was held?
Well, kindly see page 15 and
Tell me when interview was held?
that is on 11th August 2025.
Then what happened? You are a selected candidate.
No, I have been not selected, I have not been rejected, but I am the senior most teacher and that they are going to appoint junior most teacher. We have stated all 3 candidates who are there. I have stated that.
So where is the illegality? Where is the illegality in it?
Illegality
Senior most teacher does not have straight away right because selection process was conducted in terms of 10th of July 2002 circular, where it is laid down that what is the procedure which is required to be followed. If there is no procedural impropriety in that event, where is the illegal? Participated. You are not selected in the panel. So what right you have got?
Yes, premature. Premature application.
but are not selected but not rejected. That is the position. But they are going, kindly consider, they are going to appoint the junior most teacher.
Maybe that is permissible. If he or she performs well, she will get. It is not a case of teacher in charge. You are mixing up. If it is a case of teacher in charge, then you may have a right being a senior most teacher. In case of appointment of assistant headmaster, there is no provision that the junior most teacher will not get opportunity to be appointed. If she has a better academic qualification and if she performs well in the interview, then he will be appointed. Where is the illegality? You tell me where is the illegality?
No appointment has been made.
Maybe, but where is the illegality in selecting the other candidate?
3 candidates are there.
Kindly see page.
Just a minute. It is his application. Allow him.
Kindly see, there are 3 candidates. Well, 2, myself and the second one has not been selected or rejected.
I fail to understand that what you are trying to submit by selected or not selected, not rejected. Those who are not in the panel, they will not be considered for appointment. Everybody knows it. What does it mean? Selected or rejected? Who is quite senior in this profession? What sort of submission is this?
The panel has not been prepared, but
tell me that where is the illegality in it? If you can demonstrate the illegality, then court will consider it. Not selected, not rejected. Don't make this vague submission.
No. There is an assumption they are going.
Assumption. Yes. On being preparing the panel, obviously school will appoint some first time panel candidate. But where is the illegality in preparation of panel or conducting selection process? If you can demonstrate, court will come ready to consider it.
I think they are
Issue. Affidavit of service filed on behalf of the petitioner is taken on
sent to the DI for approval.
Petitioner
file this application.
Petitioner made an application. Petitioner prayed for consideration of her candidature for the post of assistant headmistress in Horinabi Shubhashini Balika Shikhalaya, district South 24 province. So it is submitted that petitioner is senior most teacher in the said school. Ota herein after referred to said school. It is submitted that petitioner is the senior most teacher in the said school who applied for the post of assistant headmistress. Therefore, she is entitled to be appointed in the post of she is entitled to be appointed in the post of assistant headmistress. Stop. It is also submitted that petitioner has performed well in the selection process. Next paragraph: state respondents and state respondents and headmistress of the said school, being respondent number 4, are represented by learned advocates who have opposed the prayer, who have opposed the writ petition on the ground that though petitioner participated in the selection process but did not come within the zone of consideration, did not come within the zone of consideration, semicolon. Therefore, after participation in the selection process, petitioner does not have right to challenge the selection process. Next paragraph: having considered the submissions made on behalf of the parties, court finds that it is not demonstrated before this court that any illegality it is not demonstrated before this court that there was illegality in preparation of panel for filling up the post of assistant headmistress in the said school. So, petitioner may be senior most assistant teacher in the school, but that does not mean that without considering the candidature of other eligible candidates, petitioner would be straightway selected for being appointed as assistant headmistress in the said school. Stop. A panel here was prepared as submitted by the state respondent, as submitted by the respondent authorities, and in the said panel of 3 candidates, petitioner's name does not feature.
Yes, third.
Stop.
Third. His position is third.
In the panel.
Yes. Yes. 19th sent to the.
So why you are saying that petitioner's name is not in the panel?
No, he's in the panel. He's third. 19th sent to the DI for approval. He third. His logo is the premature application. 19th he filed his application 19th. Premature application.
কি বলছিলাম বলো তো? Petitioner petitioner stood third. Yes, কেটে দাও। আর ওই যেখানে রেসপন্ডেন্টসরা সাবমিট করেছে সেখানটা একটু পড়ো তো। Though petitioner participated in the selection process, but she stood third in the panel. তারপর কি বলেছি? হ্যাঁ, সেমিকোলন। Petitioner does not semicolon দিয়ে বললাম after participating in the selection process, petitioner cannot challenge the selection process. না এবারে এবার কি বলছিলাম বল। আবার পরে ওই ক্ষেত্রে পড়ো। Stop. It is tried that after no, it is tried. Petitioner participated in the selection process and stood third in the panel. So after having found that petitioner will not be appointed from the said panel, the present writ petition is filed questioning the selection process. Having participated in the selection process, petitioner's right to question the selection process is withered away. Withered away. W-I-T-H-E-R-E-D. Withered away. So, moreover, it is not demonstrated that there was illegality in conducting the selection. Next.
To file a press
Next paragraph. Hence, no relief can be granted to the petitioner. Writ petition stands dismissed. No, sorry. I have gone into the merit of
On identical matter, item 47, same matter.
it.
Same matter. He stood taken,
Please call the next.
Item number 10.
May I please, your lordship? If you applicant or sub, I'm filing the arbitration.
Who is appearing for the respondent? When you have
I don't know who is appearing.
what you are praying for?
I'm praying for distribution. 3%. That is.
3% additional increment.
My lordship, or there are 7 petitioners to file.
No. You have to, court will consider in respect of one petitioner.
I shall.
No, you may file deposit court fee, but that will not permit, court will not pass any order. I have rejected others. Separate writ petitions are to be filed because they are working in different schools, in different, for a different period, so cause of action is different.
They will file for separate representation before the commission.
Yes, and separate writ petition. I will not pass any order. I will pass order in connection with the person who has affirmed this affidavit.
That is petitioner 1. Page number 22.
In respect of petitioner number 1, this writ petition will be entered. But for others, those petitioners have to take steps separately.
Separately.
Yes. Where is the affidavit of service? Affidavit of service filed on behalf of the petitioners are taken on record. Next paragraph. Petitioners prayed for sanction of 3% additional increment for manning the posts of headmasters in upgraded higher secondary schools. Stop. But petitioners ought not to have joined in one writ petition as they are holding posts of headmaster in different schools and their tenure also are different, or their periods of service also are different.
Right.
So, petitioners having separate causes of action are required to prefer separate writ petitions. Next point. Hence, present writ petition is entertained in respect of petitioner number 1 and petitioner number one.
One.
Within bracket hereinafter referred to as said petitioner. Next paragraph, and in connection and in respect of rest of the petitioners, present writ petition stands dismissed. Stop. However, this order shall not preclude petitioner numbers 2 to 7 to file separate writ petitions claiming similar benefits. Whether the petitioner number one is still working?
Yes, still working.
Why not?
And he has affirmed the affidavit.
B is not permissible, my lord. Come to para 20, my lord.
No, I will direct the commissioner to consider the 3% grant of 3% additional increase. Nothing.
My lord, my lordship's order dated 28th August 2025 in view of the division bench order.
ঠিক আছে
In view of the division bench order, as your lordship's order, I have handed to my lord. Lord, they can be at liberty to file the representation individual. Yes, to file in individual representation before the commissioner, and he will consider and decide.
Stated that you can, the other petitioners can make an application.
That is it, petition.
Huh.
I'm thinking, let them file separate representation before the commissioner so that can be
No,
considered.
that I cannot pass such order in this petition. I will take up the matter of petitioner number one. Have you made any, whether petition number one has made any representation?
Lord, yes, Lord. No, Lord, that representation is not annexed. That is page number 20.
Just a minute. You have to make a representation within 4 weeks claiming 3% additional increment, which will be considered by the commissioner by 12 weeks. Then disposed. Next.
item number 11
That is appearing using the code number 12, my lord. In the IM matter, kindly make not to be on it.
Issue. At the time of call, accommodation is paid for on behalf of the petitioners. Stop. However, state respondents are represented by learned advocate. List the matter under the same heading for further consideration on 17th November 2025. Please call the next.
Item number 12.
But 12, Lord, I'm appearing for the petition and I'm appearing with Mr. Nasuman. Lord, matter is, Lord, just identical to the matter as disposed of by your lordship in item number 10. Headmaster, retired headmaster of a high school. He has manned the post of headmaster and claims 3
When retired?
Lord, retired on 31st of January 2025. 31st of January 2025, and initially this 3% increment was given to him, but by a subsequent order, he was directed, my lord, to deposit that the additional pay, and accordingly, my lord, I have mentioned.
Then pension payment order was issued.
So he deposited the 3 lakhs rupees 47,000.
Where is the deposit?
My lord, kindly, my lord,
Challan form.
my lord, kindly come, my lord, to paragraph 23. It is there, my lord, and thereafter, my lord, P22 is, my lord, there. Annexed P22 is, my lord, at kindly come to page 75. That is the chair's challan. Column 5A, amount taka rupees 3,47,580. Page 75, column 5A.
Each page is having two separate paginations. Which paginations to be followed?
No, my lord, page 75, my lord, there is only one page.
Especially old. Especially old. এটা পাঠাচ্ছিস না আবার লিখ
No, এখানে শিফট কর।
Yeah, mention করা তো
3,47,580 you have deposited. Now you want a refund.
I want that additional.
So what prevented you to challenge this at that point of time? You deposited the amount, obtained the pension.
Lord, that I have mentioned that I have.
And then the pension payment order was issued on 28th January 2025.
And I have mentioned.
So what prevented you?
Lord, I have mentioned in paragraph 28 that I have received it without prejudice to my right to challenge it. Paragraph 28 I have mentioned.
When you have deposited it in month of September 2024.
Yes. Lord,
so why you have not challenged it, that demand?
Lord, they could not have given me the pension. They are not pressing upon.
Could have approached this court at that point of time.
Lord,
Sure.
My Lord,
Affidavit of service.
This is the judgment, Lord, passed by your lordship, Lord, in the same matter.
Affidavit of service filed on behalf, not in the same matter.
Lord,
where the petitioners are working, court is specifically or where petitioners are coming at the point when this demand is there. Otherwise, it is to be hard on affidavit. Petitioner, affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Petitioner made a prayer. No, petitioner made a prayer. The petitioner retired on superannuation on 31st January 2025. And while processing the pension case of the petitioner, state authorities demanded rupees 347,580 demanded refund of rupees 347,580 from the petitioner as a precondition to settle pension case of the petitioner. Petitioner accepting such demand made on behalf of the state authorities deposited the aforesaid sum, and thereafter pension payment order was issued on 20 January 2025. Next paragraph. Petitioner, by filing this writ petition, prays for sanction of 3% additional increment for manning the post of headmaster in an upgraded higher secondary school, thereby direction is required to be issued upon the concerned state authorities to refund the amount which petitioner deposited for settling the pension. Next paragraph, state respondents are represented by learned advocate. Next paragraph. Issue needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this petition be filed by 2 weeks after the ensuing puja vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for expeditious hearing after the time fixed herein above for exchanging affidavits. Next paragraph. Learned advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days after কাজ করো ওটাকে না এই অ্যাফিডেভিটটাকে 3 weeks করে দাও 3 weeks 2 weeks 2 weeks directed to communicate this order to the non-appearing respondents by 1 week after vacation and file further affidavit of service on the next week. I'm ready.
Item number 13.
Upper primary, my lord, first SLT. My lord, the result was published, my lord. That is that, my lord, petitioner, my lord, score page 24, my lord. Kindly come to my lord, serial number 240, 86.80. Where, my lord, the personality test he got, my lord, 7.33.
Yes.
My lord, thereafter, my lord, it was cancelled. Subsequently, my lord,
Thereafter,
with regard to the personal interview, my lord, that was cancelled in view of the, my lord, the High Court's order. It was second time.
upper primary personal test was not cancelled.
Kindly come to the next page, page 25. In compliance of the order passed by the Honorable High Court, such and such the candidate for post of the upper first assembly 26. The roll number is not.
For disposal of grievance, but the panel was not cancelled. Fresh selection process started from Rule 12(2) stage. In terms of the order, wait, here this code. In terms of the order of the coordinate. Then did you upload your testimonials?
Yes,
where you have stated that you have uploaded?
Page 26, my score was not.
Where you have stated that you have uploaded your testimonials?
Page 26, you lost.
Where you have stated you have uploaded your testimonials?
Backup number, my lord, that is.
When the fresh selection process was started from Rule 12(2) stage.
Page 9, my lord, you lost from page 9. Paragraph, page 5, paragraph 9.
Old content. Old session. What is the order, Dr. Patra, page 25, Grievance Redressal Committee?
My lord, my learned friend has not annexed the second page.
The candidate has?
He has not annexed the second
No,
page.
in the written, handwritten document?
No, this is his grievance. This box is what he has stated.
That the candidate has
Agreed.
Agreed
With his
awarded marks by the West Bengal Central School Service Commission. Yes, where is the order?
I think he has, this is aggrieved, not agreed. It will be aggrieved. And on the next page, our finding is to be there. That is not.
Where is that order?
That my man.
Page 20.
Where is the order of the Grievance Redressal Committee authority?
একটা second page হবে বুঝলি
it goes to show that there the grievance was raised against the Grievance Redressal Authority. Then an order was passed. Where is that order?
We have no order.
Has to be. Dr. Patro, take instruction and come. issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in first. It is first SLST extended for 90%.
Yes, not for 9, that is the 100%.
100%. Petitioner participated in first state level selection test within bracket 80. 2016 for upper primary level of classes and raised grievance before the Grievance Redressal Authority of the West Bengal Central State Service Commission, as it appears from a document at page 25 of the writ petition. It also appears that petitioner was heard on 20 September 2021 by the concerned authority of the West Bengal Central School Service Commission, but what was the order passed by the commission is not enclosed to this writ petition. Next paragraph, Dr. Patro, learned advocate representing West Bengal Central School Service Commission, is directed to file a report. Is directed to Dr. Patro West Bengal Central School Service Commission, concerned authority of the West Bengal Central School Service Commission is directed to file a report in the form of affidavit disclosing the order passed by the Grievance Redressal Authority in connection with petitioner's participation in first SLST 80/2016 for upper primary level of classes. Stop. Let such report be filed after 2 weeks after ensuing puja vacation. Stop. Next paragraph, list the matter under the heading under the same heading under the heading motion in the monthly combined list of December 2025. Next.
Item number 14.
Yes.
My lord, the petitioner before your lordship is a person with disabilities with 80% disability. His father was a Group C employee in a school, my lord. Father expired on, my lord, 1992. Thereafter, my lord, my mother used to, my lord, receive the...
When expired?
My lord, 21st March 1992.
When retired?
My lord, retired on, my lord, 30th of September 1991.
Died on 21st March 1992. Then mother was receiving family pension.
In receipt of family pension, that to, my lord, pursuant to order of this honorable court. My lord, mother expired on 25th of January 2005. My lord, thereafter, the unmarried daughter, my lord, my sister, she was in receipt of family pension. That to, my lord, pursuant to order of this. My lord,
who is appearing for the state?
Sir, my lord.
Serve notice upon the learned advocate representing state to come back after vacation. So affidavit of service filed on behalf of the petitioner is taken on record. So you are praying for family pension. Petitioner being an unmarried daughter is praying for family pension.
Petitioner being a disabled son is praying for.
Petitioner being a disabled son is praying for family pension. Stop. However, state respondents are not represented. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondent by 26th September 2025. Next paragraph. List the matter under the same heading for further consideration on 29th October 2025.
Can it be before vacation?
No.
Item number 15.
Disabled
state.
I do not know, Lord. So I have some.
You are for the state? Yes.
Disabled son paying family pension, Lordship.
But the disabled son is entitled to family pension. What is the circular?
circular dated 13th of January 2009.
Show me. Done. But the circular is dated 13 January 2009.
Yes, Lord.
Old circular. But pages will not tell. Mention है. In January 2009. January 2009. 10 ACB. Yes, 10 ACB. Take it back. What do you at point you must do it? Yes. Yes. Now, when the employee died
Employee
or retired,
retired 31st of December 2003, Lordship.
when died,
Died,
retired or died? Retired when?
Died 2000.
When retired?
Retired 31st December 2003.
Retired.
Retired. Died,
Died?
1st of March 2015.
But his wife was receiving
Till
pension.
her death, Lordship.
Yes.
Till her death. His wife was receiving pension till her death.
When wife died?
Died, Lordship. 18th February 24.
Now you are not in receipt of any pension. Where is your income certificate?
Income certificate, Lordship. Page 26, page 26, Lordship.
Page 26.
Yes, Lordship. Comes in, Lordship.
No, councillor certificate will not do. It has to be by the block development officer. Panchayat councillor will not do.
I apply, Lordship. I shall apply.
So you should have approached this court after obtaining an appropriate income certificate from the competent authority.
Give me after vacation, Lordship. In the meantime, I will.
This certificate will not do. It has to be by the BDO or a competent authority. Panchayat municipality councillor certificate will not do.
I shall obtain from SDO or BDO.
And where is the legal year certificate?
Legal year certificate also, Lordship, by chairman, Lordship.
That will not do. Both the certificates are
Next page, Lordship.
Are not in proper form issued by the competent authority.
Give me after vacation, Lordship. In the meantime, I will apply, Lordship.
File or affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner being a disabled son of a retired teacher, has come up with the present petition for sanction of family pension in terms of government order dated 10 hyphen capital S capital E hyphen not hyphen within bracket capital B slash একটা বড় করে দেবে O /I capital M hyphen 131 / 2008 2008 within bracket part 1 close bracket dated 13 January 2009 issued by the OSD and ex officio Joint Secretary Government of West Bengal School Education Department. So it is also submitted that petitioner's father was a teacher who retired on 31st December 2003 and was in receipt of pension and died on 1st March 2015.
Yes.
2015, stop. Mother of the petitioner after death of father was in receipt of family pension who died on 18th February 2024. Stop. Petitioner claiming family pension being disabled son. Next paragraph. However, documents which are relied upon by the petitioner. Now, however, income certificate and legal year certificate which are relied upon by the petitioner are not issued by the competent authorities. However, documents are not issued by the competent authorities. Stop. Next paragraph. Leave is granted to the petitioner to submit relevant documents issued by or requisite documents issued by competent authorities before the concerned district inspector of schools AC
পশ্চিম মেদিনীপুর।
Before the concerned district schools, AC Poschim Medinipur being respondent number 4. And lay claim for sanction of family pension. Stop. If application is made by the petitioner along with requisite documents issued by the competent authority seeking sanction of family pension, if before the respondent number 4, court expects that same shall be considered by the said respondent number 4 in accordance with law within a reasonable time. Stop. Writ petition stands disposed of. Arjun Xerox. Next. এইভাবে আছে বুঝতে পারছি করে না বইটা দিয়ে
Item number 16.
অর্পণ কে Yes.
I declared it was on the 18th.
Yes.
And there was receiving my full salary till my date of superannuation. Now, one of the matter which was pending the court regarding my approval came before the honorable sitting judge, and honorable sitting judge dismissed the writ petition, holding that I am not entitled to be approved. My appointment was made with the link. Within matter, an appeal was taken. The appeal for delivered judgment. The judgment was delivered on 27th February 2025 by holding the no, the appointment is approval is required to be given, and order of the sitting judge was set. The last portion of the order, if you losses kindly have a look at this appeal court's order, page 46, paragraph 20.
Yes.
Now, when it appears, the district expert disputes short for instruction from the page 51, later of the district expert.
51.
51.
Commissioner of School Education was requested to instruct
Yes. We have
in
not-
view of the judgment of the
Honorable division.
division. Yes.
Till date, no.
Regarding what? This instruction regarding pension.
Yes. Approval was not given permanent basis. The court said.
Now you retired on 31st May
31st May.
2018, but the
2018.
government treated it as a appointment on a temporary leave vacancy.
Yes.
Now issue was settled by virtue of the judgment of the division bench on the 27th February 2025. Now you are entitled to get pension on the strength of the division bench judgment. That is your case.
Matter is pending before the commissioner, according to my instruction, because the DI.
What remains? Settle the pension case, because everything is settled by the division bench. When the division bench has said, such being the position, the government cannot prevaricate its stand from the stage of the appointment to the stage of an approval, and therefore we find that the decision of the appropriate authority that the appointment was purely on a leave vacancy is not sustainable, nor appears to be in consonance with the documents produced before us. The order says that the appointment of petitioner should be regularized by giving the post facto sanction and approval.
DI asks for the authority commissioner, and that is pending. Either the lordship that is the DI or the commissioner, because mandatory order has done, government has not preferred any appeal against that order. So it is binding.
So the right of the petitioner got crystallized with a judgment dated 27 February 2025.
Yes, certainly. I am admitting that. But no steps has been taken subsequent there. So either will DI approve.
Whether the school authority has forwarded the pension case?
Yes, the papers. I'm sorry, that is not.
If it is not forwarded, what is the question of
Page 26, your lordship kindly have it. Page 26.
Yes.
Page 26 is the letter of the headmaster addressed to the district inspector. That is 1993.
Page?
No, that is not.
School has not forwarded.
Yes, if the school has not, I do not know, I am not in a position to apprise this school whether it has been forwarded.
I think
No, what basis court will give direction?
He made an application before the school authority, page 49, your lordship kindly.
No, when the school authority was served?
The school authority, I made an application on 19th June 2025.
Show me the service upon the school authority.
Yes.
Hey, the
result.
Specific direction was the district director. Page 24.
Item delivered on 4th September. No, proceed.
Whether any post facto sanction or approval was granted?
No, after the division bench judgment, that's it. That is the exact letter of the district inspector schools.
By giving post facto sanction, or then you have to initiate a contempt proceedings. Because the appointment of the petitioner should be regularized by giving post facto sanction or approval within a period of 4 weeks from date. So if it is not done, then post facto approval or sanction has to be accorded. Otherwise, on what basis this pension is to be pension case to be settled? There will be a confusion from which date it is to be granted.
Your lordship kindly, my submission would be to the lordship the letter of the DI. Your lordship kindly have it. Letter of the DI. Recently, paragraph 7. Recently, Honorable Division Bench Calcutta High Court passed the matter such and such being the position. the government cannot predicate it. It's a stand from the stage of the appointment to the stage of approval. Therefore, we find the decision of the.
This is paragraph quoted paragraph 21, 22, 23. In respect to judgment order, it is my humble request for necessary. Problem is, from a particular date, your service is to be reckoned.
Yes.
So that has to be done by in terms of paragraph 23. Otherwise, this court, how this court will direct the authority?
Because of the Commission of the School Education session in the matter, is asking for the instruction.
No, but if within a period of 4 weeks, this regularization or post facto sanction or approval was not granted, you initiate a contempt proceeding.
That is the separate. Contempt will not serve the purpose. Contempt, my lord, for the
no,
because of
for granting post facto sanction and approval.
Your lordship kindly appreciate my lord. The person will have to initiate a contempt. Contempt approval will be given. Then, my lord, I again have to approach.
Otherwise, what will happen?
Your lordship kindly.
In the case of
in the
case of settling pension case,
no,
from X date to Y date, your pension is to be regularized. If X date is the date of appointment or date of granting post facto approval as per post facto approval,
I tell you, lordship.
if X date is not fixed, then your pension cannot be regularized.
Then Commissioner of School Education. Commissioner of School Education was a party before the division bench. The order is binding upon him. Let him take instruction or let him submit a report. Unnecessary dragging the persons 2018 he retired.
That is not the way of getting.
No, because of the fact
the division bench.
No, the district inspector should wrote a letter to the Commissioner of School. What is the response to this? If the any difficulty is there, he can apprise the court.
Ultimately, it is the order of the division bench. So therefore, division bench's order has to be complied with by issuance of post facto sanction.
Is no response. What is the reason? I believe, my lord, the Commission of School Education.
That's why division bench consciously directed that the appointment of the petitioner should be regularized by giving post facto sanction or approval within a period of 4 weeks. If this post facto sanction and or approval is not accorded, then there is a difficulty in processing your pension case.
The DI is confused because of the fact approval is required to be given by the DI. DI is writing a letter to the Commissioner of School Education. And he is confused. This is not the deliberate action or manner. They are willfully violating the procedure. That is not the case. They have taken steps. And 2018, the person was retired. Not a single funding has been. Your lordship can ask the
today you could have approached this court that this is the post facto approval from a particular date. From which date it is to be counted.
From the
that has to be by the order to be passed by the state authorities in terms of paragraph 23 of the division bench judgment. So if that is not there, where is the scope of processing your pension case? Nobody knows what is the date of your commencement of service.
Commencement service can be recorded in the judgment itself.
Where? But that may be recorded while considering the making submissions.
Yes.
But court directed to regularize by giving post facto approval, sanction or approval.
Your lordship
Yes.
Already approval is given. Date has also been mentioned by the DI.
Where is that?
Page number 24.
On 22nd March 1992, 19 or 19. Temporary, that will become permanent. So initial appointment on 22nd March 1990.
16 July 1991
Yes,
memo.
Yes.
How it is possible? It has to be in terms of the order dated 27 February 2025, Mr. Chattopadhyay.
When he was joined in a leave vacancy.
Where is the compliance by the state authorities for issuance of post facto approval?
No, that part has not. Your lordship.
Why you are misleading this court?
No, I am not misleading. Your lordship, where is the date?
So that has to be determined in terms of section paragraph 23.
That misleading. Never try to.
So why you are saying this? 1991 memo. I thought after this, there Mr. Badi is correct.
Thereafter, no order has been passed. Your lordship query from what date you have?
So there has to be a formal approval of appointment on post facto basis.
Your lordship
not been done for this. The order has been passed.
Madam, may I suggest one thing, your lordship?
That is the purpose. Court division bench consciously directed that regularizing that issue you cannot cross this hurdle in a manner by filing another writ petition. Then I have to direct the authority to determine the date of appointment of the petitioner first.
That's kindly do that. That will be better. Entire repetition can be.
Division bench move and contempt application.
It will unnecessary.
Let me direct the authorities to exchange affidavits in the meantime.
Exchange affidavit. Do that. Sure. Let them disclose their status.
There is a specific direction in paragraph 23 that will not be complied with.
Certainly, I'm admitting that that is complied with, because for this reason I forwarded to the commissioner. What we will do? Now it is pending before the commissioner. Either your lordship direct in view of the division bench judgment, according to me, I am not misleading or submitting anything, on the basis of the date of approval, or the commissioner will consider.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next. Petitioner, by filing this writ petition, has laid a claim for sanction of retirement dues, including pension, since as he retired on superannuation from the post of assistant teacher on 31st May 2018. Claim of the petitioner for sanction of retirement dues is on the strength of judgment of the Honorable Division Bench dated 27th February 2025, passed on an intra-court appeal being MAT 1810 of 2024, within bracket Mohsin Gayur, G-A-I-U-R, Gayur versus the state of West Bengal and others, close bracket. Next paragraphs. State respondents are represented by additional government leader Mr. Supriyo Chattopadhyay. Let's stop. Next paragraph. On perusal of the judgment dated 27th February 2025, it appears that the Honorable Division Bench negated the submission made on behalf of the state respondents before the state negated the submission made made before the court that the appointment of the petitioner or appointment of the appellant was purely on leave vacancy, comma, and purely on leave vacancy, comma, therefore not sustainable, nor appears to be in consonance with the documents produced before the Honorable Division Bench. Therefore, decision of the appropriate authority was not sustainable, nor appears to be in consonance with the documents produced before the Honorable Division Bench. Stop. ঠিক আছে? Consequently, in paragraph 23 of the said judgment dated 27th February 2025, Honorable Division Bench directed that appointment of the appellant / petitioner needs to be regularized by giving a post facto sanction and or approval within a period of 4 weeks from date, or within a specified time. Within a specified time. Stop. Next paragraph. However, it appears from the submissions made on behalf of the parties that till date, post facto sanction and or approval as directed by the Honorable Division Bench has not been accorded, excepting a letter was issued. Where is the letter of DI?
Page 51.
Was issued by the District Inspector of Schools AC Uttar Dinajpur dated 5th May 2025, thereby requesting the Commissioner of School Education West Bengal to give necessary instructions. Stop. Next paragraph. Commissioner of School Education West Bengal being respondent number 2 is directed to file a report disclosing steps taken by the state authorities for according post facto sanction and or approval for regularizing appointment of the petitioner. In terms of the directions as contained in the judgment dated 27th February 2025 delivered by the Honorable Division. Let such report be filed by the respondent number 2 by 1 week after ensuing puja vacation. Stop. List the matter under the same heading for further consideration on 4th November 2024.
Item number 17.
Mr. Chattopadhyay, if division bench would have been satisfied regarding issuance of approval of 1991, then there was no necessity to give direction to issue post facto approval.
It was a lawsuit query from what date, madam?
That's why division bench directed to issue post facto approval for regularizing the service of the petition. So therefore, 1991 memo is not relevant in taking decision today. At the stage when the division bench already delivered a judgment. That there is no requirement. Division bench could have directed that there is no requirement to give further direction for post facto approval. Yes, next matter.
Item number 17.
For this thing. Regarding
Yes.
the father of the petitioner,
Widow daughter family pension. When father died,
3rd October 2005. There was the mother also died. Father was getting the pension. Then my lord, mother was getting pension. Mother died.
father was a teacher.
Was a teacher. She's a teacher. Then because of
Mother died on
died on 27th February 2015.
so what you are doing for such a long time? For 10 years.
Thereafter, my lord, her husband, my lord, died on my lord 16 August 2009.
2019. Thereafter also 6 years have passed.
I have stated in contract that he was not aware of the legal.
What your husband was doing? Merely death of husband will not confer right to get family pension. If you are entitled to get certain benefits due to death of your husband, then
No, he is not getting my lord.
where you have stated?
Video also.
Where you have stated?
Hello, Fantasy my lord, annexure P6, page 25. The bidder issued certificate. Issued certificate that page 25. Page 24 is the legal asset certificate. Was a district page 24. And it's just P5.
Page 24 and P5. Take steps. Legal asset certificate is there also by the competent authority.
Page 26, ma'am.
And then the income certificate by the
Yes, ma'am.
block development officer.
Petitioner was getting one fisherman old age pension, my lord.
That is 3,000 per month.
No, ma'am, page 26.
Page 20.
26. Discontinue from 8th April, ma'am. After that, she had applied for the family pension.
Although I have received a report from the DI, my lord.
Yes, yes.
I said, my lord, if application is made to the DI, my lord, the DI will consider the application. Paragraph 2 and 3, my lord.
Issue. File your affidavit of service. Petitioner has prayed for direction upon the concerned respondent authorities for release of for release of family pension. Being widowed daughter. The father of the petitioner was a teacher who died on 3rd October 2005. Stop. Father was in receipt of pension. Stop. After death of father, mother was receiving pension who died on 27th February 2015. Stop. At the time of death of mother, petitioner's husband was alive, who subsequently died on 16th August 2019. Stop. Petitioner made application for sanction of family pension, and in support of same, legal year certificate dated 15 January 2025 and income certificate dated 14th March 2024 issued by the competent authorities are relied upon, which are annexed to this petition. Next paragraph. Have you made a formal prayer before the DI?
Yes.
Where is that?
It's a P8.
Page?
P8.
23. 23.
29. No, DI forward. Page 23, madam, this is my prayer. Then one DI also.
School forwarded. This was forwarded by the school authority.
That is page 29, but DI did not receive it, man.
No, I have
Received by DI.
23, ma'am. I have with the
How DI has received it? It is a prayer to the headmaster. Then headmaster forwarded it to DI. You make an application directly to the DI.
Yes.
Next paragraph. Leave is granted. State respondents are represented by learned advocate who has submitted. If direction is given upon the concerned district inspector of schools, AC Purbo Medinipur being respondent 5, prayer of the petitioner for sanction postgraduates for sanction of postgraduate prayer of the petitioner for sanction of family pension to be considered in accordance with law. Next paragraph. Having considered the submissions made on
documents have to be sent by the school to the DI. So kindly direct the
next paragraph. Having considered the submissions made on behalf of the parties, writ petition stands disposed of, granting leave to the petitioner to make a representation to the district inspector of schools or to the respondent number 5 by 4 weeks from date, enclosing necessary documents, leaving family pension. Stop. If such representation is made within the aforesaid time, respondent number 5 shall decide the same in accordance with law by 4 weeks thereafter. Stop. While deciding the claim of the petitioner, respondent number 5 shall also be at leave to ask for relevant documents from the school authority where father of the petitioner was working. was working. So, decision to be taken by the respondent number 5 shall be communicated to the petitioner by 10 days thereafter. Next paragraph. If petitioner is adjudged to be eligible to receive family pension, consequential steps shall be taken for settling family pension case of the petitioner at an early date for releasing family pension in favor of the petitioner. Urgent Jalak Pratibad Karo.
Grateful, grateful.
Item number 18.
Yes, teacher of India. They are appointed as guest teacher. After appointment of the regular appointment, they have determined there are some areas. I have read for preschool.
Area accrues for what?
Area for what?
Guest teacher?
Salary will giving the effect memo which are for the government for the 8% increment for the 8% for the interim.
They have already paid your also only they are getting enhancement of DA that they are getting some interest with 8% interest. They are paid for.
Very well, place your case on facts.
Where the petitioner was appointed as a guest teacher in the year 2006.
2006.
There are 16. There are 6 petitioners.
All are the same school.
Three petitioners.
No, six.
All are in same school.
Same. 1 to 5.
All are their dates of appointment are same.
1 to 2016 and
Where is the court fee? Why not? Issue. So there are 6 petitioners, but it appears that court fee in respect of one petitioner was deposited at the time of filing of this return. Next paragraph. Leave is granted to the petitioner to deposit additional court fees by 26 September 2025. So, next paragraph. List the matter under the same heading. On 11th November 2025. Next.
Item number 19.
At the time of call, accommodation is paid for on behalf of the petitioner. On behalf of the petitioner, however, respondent authorities are represented. Next paragraph, list the matter under the heading motion in the monthly combined list of November 2025. Next.
Item number 20.
Medical and child medical. Disabled. So if 80% disabled, then is it a ground for transfer? No, under the rules, whether disability of son or daughter is a ground. I'll come back at 2. No, it is not the mentioning time. Please call the list. Sorry, it's not an mentioning time. Please call the list.
Continuing item number 20.
Mention tomorrow morning. Yes, petitioner applied for transfer on medical ground on 18 September 2022. On medical ground, self-medical ground. Then what happened?
Wow. Okay. Absolutely.
What you are doing for such a long time? 22, 23, 24, 25, 3 years. August 3rd August 2017. Thereafter 5 years passed. So 18, 19, 20, 21, 22. Just after 5 years, again application. But what you are doing? For 3 years. Where is the case made out regarding delay, explaining delay? On 29 September 2022 is the date from which date portal was suspended. That's why application was not considered. No steps were taken.
No steps. Paragraph 10.
But mutual transfer is not a ground since 5 years have already expired, and this is an moreover this is an application on medical ground.
Medical ground.
But medical ground was not covered by the 4A.
Yes, 5 years is 5 years. 5 years.
Medical gynecology problem, that problem that is not covered by that.
In case of medical ground transfer, that part of 5 years is not applicable. In case of transfer on general ground, 5 years bar is applicable. Let it be re-examined by the DI.
No,
medically examined.
Examination not done.
Examined by the DI. It has not been done.
Not been.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner made transfer to the portal since she was suffering from gynecological disorders. Petitioner since she was suffering from gynecological disorder. So application was made for transfer on 18 September 2022, which was forwarded by the school authority where petitioner is presently working to the concerned district inspector of schools AC. Bankura being responsible 5 for taking further steps. Grievance of the petitioner is her transfer application is yet to be decided. Next paragraph, West Bengal Central School Service Commission and state respondents are represented by learned advocates. Next paragraph, next paragraph, it is submitted on behalf of the respondent authority দেখে করো ভীষণ ছোটখাটো অনেকগুলো কারেকশন করে এলাম গ্রিভান্স অফ দ্য না কি বললাম authorities that as per norms applicant teacher is required to be medically examined by the concerned chief medical officer of health or medical board in order to ascertain the ascertain health condition of the petition. So it is also submitted that till date petitioner has not been medically examined by the medical experts due to suspension of portal. Next paragraph, having considered the submissions made on behalf of the parties, respondent number 5 is directed to obtain a report on medical examination of the petitioner from the chief medical officer of health, from the concerned chief medical officer of health plus medical board by 4 weeks from the date of communication of this order. Stop. In the medical report, CMOH/medical board is required to opine considering present health condition of the petitioner whether she is required to avoid long distance journey on. If medical report justifies transfer of the petitioner, transfer application along with medical report shall be forwarded to the West Bengal Central School Service Commission by fortnight thereafter for taking decision. Stop. On receipt of transfer application and medical report, Secretary, West Bengal Central School Service Commission, being respondent number 4, is directed to decide the same by 6 weeks thereafter, and decision to be communicated to the petitioner by 10 days thereafter. Stop. Next paragraph, it is made clear the suspension of portal shall not be a ground to reject transfer application of the petition. Stop. Writ petition stands disposed of. Okay. Next.
Item number 21.
You are praying for time? Yes. Yeah, for the state.
And for the commission.
For the state. Commission?
And for the commission.
Where is the application? Several applications were made by the petitioner.
On distance travel, but last application is distance travel.
It was sent to the commission by the DI. So let commission take decisions. Issue. File your affidavit of service. I have not called for any report. This is for you. Court has not called for any. Reading this report, if you find anything relevant, you can submit before this court.
She has applied for this transfer and
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner made an application for transfer on general ground within bracket distance. Stop. Application for transfer was made on portal on 8 September 2022, which was forwarded by the concerned district inspector of schools. Which was forwarded by the forwarded by the school authority where petitioner is presently working to the concerned district inspector of schools AC for taking steps. Next paragraph, next paragraph, stop. District inspector of schools AC in turn process the transfer application and forwarded the same to the West Bengal Central School Service Commission on 15 September 2022. Stop. Grievance of the petitioner is transfer is her transfer application is yet to be decided by the concerned authority of the West Bengal Central School Service Commission. Next paragraph, it is submitted by the learned advocates representing the respondent authorities that due to suspension of portal, contemporaneous decision could not be taken on transfer application of the petitioner. Next paragraph, however, it is submitted on behalf of the commission if concerned authorities directed, transfer application of the petitioner shall be decided in accordance with law. Next paragraph, having considered the respective submissions made on behalf of the parties, writ petition stands disposed of directing the Secretary West Bengal Central School Service Commission being respondent 4 to decide transfer application of the petitioner by 6 weeks from the date of communication of this order, and decision to be communicated to the petitioner by fortnight thereafter, by 10 days thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject transfer application of the petitioner. Urgent xerox certificate. Next.
Item number 22.
Self-medical ground. Just a minute. Yes.
My lord, here, my lord, the petitioner obtained, my lord, general transfer in 2019. And then again, my lord, he has applied for transfer under the same rule in 2022. But my lord, as per the amended provision, rule 9, my lord, the one. My lord, rule 9, my lord, the incumbent, if otherwise eligible, may again apply for general transfer after completion of 5 years of service from last transfer. Medical. Rule 9.
Yes, that is admissibility of general transfer.
General transfer.
But a transfer on special ground?
Medical. That has not been classified.
Transfer on special ground?
That relaxation has been given for medical
Show me the
ground.
relevant provision.
No, my lord, after subsequent amendment, that relaxation has been given for in case of medical transfer. 5 years of continuous service in the present school is not required, but the continuous in his entire service life.
Entire service period 5 years.
That relaxation is there. That relaxation is there. That is for, my lord, eligibility for 5 years, continuous 5 years. But here, my lord, once he has obtained transfer under the same rule in 2019.
Yes, but that is on a ground, on distance ground.
That I don't know, my lord, whether
But once transfer is allowed, whether it can be a bar for transfer on special ground.
No, my lord,
previously the provision was for mutual and general transfer, both. If one has obtained transfer either in under the mutual transfer rule or in the general transfer rule, then again, Mala, there was a bar of 7 years.
But if it is a transfer on special ground, under rule, under rule 3.
Yes.
Yes. Then, or rule 4.
Rule 4 is special ground.
Yes, yes. Under rule 4, then rule 4A. 4A, what is required is 5 years service.
5 years
as a whole.
As a whole, in his entire
Where
service.
is that rule?
Well, that is subsequently that amendment is there. Well, in the compilation. Well, this is
5 years
December
taken together.
December 2022 notification.
Yes. 21st December 2020. Five years of service in the present school shall not be applicable to the applicant who has completed overall 5 years in the service.
Yes, that is my eligibility. Eligibility for applying for transfer.
Yes.
Now, Mala, there is a further bar under the amended rule 9. It was previously there was a bar for 7 years in case of mutual transfer and general transfer, all kind of transfers. Subsequently, it was amended, and Mala, this 5 years bar was inserted, amended, and 5 years bar inserted only for Mala the candidates who have obtained general transfer, not mutual transfer. That has been omitted. So, Mala, double benefit should not be Mala.
It says amended rule under 21st December 2021 that the incumbent shall be eligible for general transfer only if she is confirmed in service and completed 5 years of satisfactory service in that particular school from which she seeks general transfer.
This is the amendment of rule 3.
General transfer. However, for seeking transfer on ground mentioned in clause A to D of rule 4, completion of 5 years of service in the present school shall not be applicable to the applicant who has completed 5 years, who has completed overall 5 years in the service.
Yes, this is one amendment of rule 3.
That issue is decided by this. No, don't try, don't invite further decision from this court. It has already been decided. If you are aggrieved, prefer an appeal, get an order from the Honorable Division, means court will follow.
Great.
And not only this, I was also considering if this application for transfer was made prior to this amendment. No. This amendment is dated 21st December 2021. Application was made on 8th of March 2022. After that, 21st December 2021 amendment, then 8 March 2022.
Yes, subsequent.
But it's an old application. The fresh report is to be obtained. Since Mr. Bandyopadhyay is making an argument that it is not applicable. A petitioner has taken a transfer that that does not mean that he will not be medically examined. After. Yes.
Mr. Bandyopadhyay suddenly mentioned that clause also in the my lord passing on.
No, no.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Take it back. It's not
Fine.
required. Petitioner made an application for transfer on 8 March 2022 on portal on self-medical ground or on on portal since petitioner was suffering from gynecological disorder. Stop. It is submitted that petitioner was medically examined in 2022 in connection with her transfer application dated 8 March 2022, therefore petitioner is therefore if it is required, petitioner may be medically examined again by the medical experts. Next paragraph. Respondents are represented by learned advocates who have submitted that transfer application was made by the petitioner far back on 8 March 2022, and in the meantime, due to constant care and treatment, health condition of the petitioner may have improved. As 3 years have passed after last transfer application was made on 8 March 2022. Next paragraph. Having considered the respective submission, it is also submitted on behalf of Commission that petitioner was once transferred on the ground of distance in 2019. 2019. Stop. Next paragraph. Having considered the submissions made on behalf of the parties, the District Inspector of Schools, AC, Murshidabad, being respondent 5, is directed to obtain medical report on medical examination of the petitioner from concerned Chief Medical Officer of Health / Medical Board by 4 weeks from the date of communication of this order. Stop. In the medical report, CMOH / Medical Board is required to opine considering present health condition of the petitioner, whether she is required to avoid long distance journey or not. Stop. If medical report justifies transfer of the petitioner, transfer application along with medical report shall be forwarded to the Secretary of West Bengal Central School Service Commission by fortnight thereafter. Stop. On receipt of transfer application and medical report, respondent number 4 shall decide the same in accordance with law by 6 weeks thereafter. Stop. Decision to be taken by the respondent number 4 shall be communicated to the petitioner by fortnight thereafter. Next paragraph. It is made clear the transfer application of the petitioner shall not be rejected on the ground of suspension of portal. Next paragraph. Writ petition stands disposed of. Great question.
Item number 23.
Accepted their proposal.
When application was made?
Date of application is what I was saying information in the month of January
2025.
after initiation of the.
Yes, let it be considered, Mr. Rai.
It is applied on 30th July 2025.
Where from you are getting it?
Page 21.
Yes.
Extreme right corner. Page 21.
Yes.
It should be extreme left corner.
30th July 2025. 4:02 p.m.
The two writ petitioner. I don't know whether both fees has been deposited or not. Another thing, my lord, your lordships already decided the issue, my lord, directing the secretary to consider, and petitioners were directed to produce the NOC and all the requisite
Because
documents
directly it was
sent to the commission.
where is the NOC? Where you have stated?
NOC, there is, but I have applied in the portal.
School cannot be kept in the dark.
No, but I have served the.
Show me that you have obtained NOC.
Online transfer, there is no commission for NOC.
In 2012 rule,
Who will be online applied?
you
The school will not be able to know when you will be transferred, whether you have applied for behind their back, you will be transferred.
As per the rule.
In the online portal, there may not be any place, but in the rules, there is a provision under 2012 rules that you can, how you can give a go, how this requirement can be given a go by. Why? Why you have not stated in your writ petition that you have obtained NOC?
NOC, my lord, since I have applied in the portal, and there is no.
In the portal, there may not be any place.
Yes.
But if rule requires,
Yes.
then you have to obtain NOC.
Yes, my lord.
Portal cannot override the rule. So therefore,
At the time of hearing, my lord.
no, why?
Then, my lord,
If no NOC is produced, then why it should be considered? At least you should make an you make an averment in the writ petition that NOC has been issued by the respective school authorities on so and so date and so and so date.
That I have not seen since there is an application in online portals. They have offered.
If you have obtained NOC, then file a supplementary affidavit.
No, there is no.
You have not obtained any NOC, then how the authority will consider it? If today court directs the secretary to decide, and if you do not get NOC from the school authority,
But my lord, what has it been under subject to correction, when I have subject to correction of my granted fee, when the my lord online portal started mutual transfer, they will automatically, maybe it is in rule. It is in rule, my lord, there is in rule. But when they facilitate the transfer, since there is an easier process, portal has.
show me that rules.
2012 rules, there is a provision.
okay, tab back.
If it is prescribed pro forma, there is a problem.
Which rule? Rule?
2012.
Yes, 2012.
Rule 6 possible. Rule 6 possible.
Yes. Rule 4.2. The application so submitted shall contain no objection and declaration of the school, as mentioned in part 2 of the form under signature and seal of the secretary, managing committee, or the administrator of the school, and the headmaster and headmistress of the or teacher in charge, as the case may be.
Yes, but that part cannot prescribe pro forma as well.
So if you have not obtained no objection, nothing can be done. And part 2, there is an indication that how the form of no objection is appended.
Then, if this applicable issue, then 1,000 rupees of demand draft, everything is supposed to. Later, I am submitting at the time of hearing, I shall produce. At the time of kindly consider. At the time of hearing, consider the NOC.
If you can, by filing a supplementary affidavit, you can produce. Yes, what Lord saying? A few minutes back, you have submitted, no, you have no objection. Yes, sure. No, sorry. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioners made an application for transfer on mutual ground, and prayer is made for consideration of their application. Prayer is made for consideration of their applications. by the concerned authority of West Bengal Central School Service Commission. Next paragraph. Learned advocate representing West Bengal Central School Service Commission has pointed out that in terms of Rule 4 within bracket 2 of the West Bengal School Service Commission within bracket mutual transfer close bracket rules 2012, petitioners are required to submit no objection and declaration from the respective schools, from their respective schools, along with their transfer application, along with their mutual transfer applications. Stop. But in the present case, petitioners have not stated in the writ petition whether they have obtained no objections or not. Stop. On next paragraph. On query being posed to the learned advocate representing the petitioners, whether petitioners have obtained no objections from their respective schools, comma, court does not get satisfactory reply. In the writ petition, no statement is made whether petitioners have obtained no objections. Petitioners have obtained no objection as required in terms of Rule 4 within bracket 2 of the West Bengal School Service Commission within bracket mutual transfer close bracket rules 2012. Stop. In view of absence of no objections, prayer of the petitioner ought not to be allowed, as the same would be contrary to Rule 4.2 of the said rules of 2012. Next paragraph. Hence, the writ petition stands dismissed. However, this order shall not preclude the petitioners to take steps for their mutual transfer in accordance with laws. We will get back the rules after time.
Item number 24.
The last occasion, Lordship. My lord, we are the job losers. Petitioner is a job loser, participated in the upper primary counseling, called for counseling, but since he was into the service of 26,000, she could not participate. So, my lord, the similar order your lordship has passed, allowing for the ensuing.
They are the job losers.
Job losers.
Now they are praying for extension of validity of recommendation.
No. They want to participate in the ensuing counseling of the upper primary. That your lordship allow this several matters.
Show me the order.
But may I only point out one thing? They lost their jobs 3rd April. Panel is expiring 25th of September. That is just within a few days. They sat idle for all this time.
No, whether you will hold any counseling.
Possibly within the lifetime of the panel, there will be no further counseling because there is no notification yet. Normally, notification comes 7 days or 5 days in advance. So I don't think, but I don't have any specific.
No, if court directs that if any counseling is held, petitioner will be permitted. Otherwise, question does not arise. For the to accommodate the petitioner's, court is not directed to hold any counseling.
Within the lifetime of the panel or beyond?
That is your decision. If you beyond the lifetime of the
beyond
panel,
we cannot
by
hold.
extension of the panel.
No, there is no provision.
Court will not enter into. If you hold the counseling, then court will then you will permit. Otherwise, the question of permit.
There is a direction of Honorable Division Bench.
Yes,
there is the order.
Please wait.
Yes.
Please share it with me, the division bench order.
I have handed over to your lordship.
I cannot see it.
Yes, Mr. Dr. Patro, you go through the division bench order, come back day after tomorrow.
Anyway.
Yes. Not today, not tomorrow.
Well, it has been given to up to 20th of November. Time has been
Different context.
Well, I'll come back not to,
Totally
not to.
different
Yes, yes, please
time
to the next
is
matter.
not to.
Adjourn till Wednesday.
This category.
Adjourn till Wednesday.
The division bench has said it is to be conducted.
Call the next matter.
Item number 25.
Adjourn till Wednesday.
Item number 26.
Transfer on technical ground. Pending before the commission. For application. For page 21. Page 21. Under 29th December 2021 application. And that's on 9th of February 2022.
Where is your transfer status of transfer?
At page 21.
Who is for the state? On medical ground.
Medical.
The court has to direct the DI. Who is happening for the state?
That I have some.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Land advocate for the petitioner is next paragraph. State respondents are not represented. Next paragraph. Land advocate for the petitioner is directed to serve notice of upon the land advocate representing the state respondents by 26 September 2025. Stop. List the matter under the same heading for further consideration on 4th November 2025. Next.
Item number 27.
Not today, not tomorrow.
I am for the commission.
Yes.
Item number 28.
Oh, then. Petition of clear for validity of the recommendation.
Validity of recommendation within 90 days. Who is for the commission? Who is for the commission?
But I have served.
Serve a notice.
Well, may I submit one thing? In the paragraph 2, the West Bengal paragraph 2, my on 6/2/19, the West Bengal Central Full Service Commission issued appointment recommendation in his favor for the post of assistant teacher in mathematics grade in class 9-10 level in ST category. Then, my lord, paragraph 4, your petitioner then he was selected on OBC B group category.
OBC.
Yes.
So what?
Oh, which category he belongs, my lord?
So that's why court is directing that another notice be served and the commission be represented before this court. Next. Affidavit of service filed on behalf of the petitioner is taken on record. In spite of service of notice, West Bengal Central School Service Commission is not represented. However, state respondents are represented by land advocate. Next paragraph, land advocate for the petitioner is directed to serve notice upon serve notice upon Dr. Sudhanu Patro, learned advocate, who is present in court. Stop. Dr. Patro is directed to obtain instructions. Stop. List the matter under the same heading for further consideration on 10th November 2024. Next.
Item number 29.
I'm for the state.
That pertains to literal repeat of the petition. That petitioner has been superannuated of the post.
No.
2020. 30th September 2020, but there is a disciplinary proceeding pending before the board. Ultimately, board passed a necessary order upon the school authority to clear entire building. However, the school is not issuing, not releasing intervention. That is the
When petitioner retired.
third. So by 31st of December 2020.
2020.
Yes.
What was the outcome of disciplinary proceeding?
My lord, kindly see. My lord, disciplinary proceeding, as there is no charge has been established, and the authority is directed to school authority to clear entire benefit in favor of the.
Now, who has directed to clear the benefits?
So board has directed all the parties that the petitioner has worked on law, and when he was appointed, no such queries were made, and then after his return.
Yes, then why it is not being released?
But I pay for this school.
Yes.
But first of all, your lordship kindly sees the power and duties of the board. Whether in a rule 3, kindly have a look. But in a disciplinary proceeding, which was requested by the district inspector to initiate, whether the board can issue this order or not to release the.
You can challenge.
I tell your lordship.
It is not your writ petition.
True. But kindly sees what is the case is all about. It is a fact that
not your writ petition.
True. But your lordship kindly.
True. You have not challenged it and you will make extempore submission.
No. The rule does not say so. If the rule does not give the power to the board to pass this order, how the board can pass this order is a nullity. Kindly have a look to rule 3 once. Then your lordship kindly hear me for 2-3 minutes. He produced a fake certificate of B.Ed. When he was appointed, kindly have a look.
Not fake certificate.
Yes.
Institution has no.
Yes, which rule you are relying upon?
Rule 3, kindly have a look. বইটা দাও দিন জজ সাহেবকে
No, আচ্ছা বই লাগবে না ওকে দিয়ে দাও
the
rule 3
yes before that your
powers and duty of the board rule
yes
3, yes
but before that kindly turns to page
no please come to rule 3.
I will
which part of the rule you are rule
yes
rule 3
the board subject to any rule order or direction of the government or the commissioner shall have the following power and duties: to appoint headmaster, headmistress, to issue a recommendation, confirmation of order of in respect of service, then to give effect to the recommendation of transfer, to take disciplinary action against the misconduct, to collect vacancy report, to maintain and as appointing authority reservation roster of the post. Then the board shall obey any general or specific order of the government or the commissioner of school education in the interest of the education. Where is the order by directing the DI of the school to release the pensionary benefit? That is not within the domain of the board.
You are somehow missing the point or is not trying to understand the issue. Because petitioner retired on 31st December 2020.
Yes.
Since the proceeding was initiated and it was under consideration before the board, it was not considered, it was under consideration before the board. That's why pensionary benefit was not released in favor of the petitioner. When board found that no, this is not a case for initiation of disciplinary proceedings, board has clarified it that petitioner is entitled to receive benefits.
No, my case is something else. Kindly hear me for 2-3 minutes. This kindly turns to page 31 of the writ petition. This is a letter of 2022 issued by the deputy secretary to the district inspector. But I have no role to play here.
Suppose before the disciplinary authority issue is pending. During that time, any incumbent retires. Under the relevant rules, generally, incumbent is not entitled to get settlement of pensionary dues. When disciplinary authority on exercise of power finds or after completion of exercise fines. No, it is not a case of initiation of disciplinary proceedings. It is the duty of the disciplinary proceedings to clarify it that yes, incumbent is entitled to get pensionary benefits, irrespective of whatever is what is there in the rules.
But I have one thing to submit for your lordship.
Because board knew that since it was before the board in connection with disciplinary proceedings, petitioner is not getting pension.
Well, that is not the issue. Kindly have a look to page 31 once. It is the interdepartmental correspondence between the deputy secretary. Can you hear me?
I have heard it.
Well, I have not completed my argument.
Yes. Affidavit of service
Then
filed on
here.
behalf of the petitioner is taken on record. Next paragraph. Petitioner, being an assistant teacher, has retired on superannuation on 31st December 2020, but till date, retirement dues are not released. Till date, pension case of the petitioner has not been settled, and retirement dues, including pension, are not released in favor of the petitioner, triggering present writ petition. Stop. Next paragraph. Petitioner prays for direction upon the concerned respondent authorities for issuance of for releasing retirement dues, including pension. Next paragraph. Learned advocate representing the authority of
only the headmaster has been made a party. School is not the party.
Jara High School. Learned advocate representing the headmaster. Learned advocate representing respondent number 6 has opposed this writ petition on the ground that President of the West Bengal Board of Secondary Education is not authorized to issue direction issue clarification relating to entitlement of the petitioner to receive retirement dues. So in this regard, reliance is placed on Rule 3 of the West Bengal Board of Secondary Education, within bracket appointment, confirmation, conduct and discipline of teachers and non-teaching staff, close bracket rules 2018. Stop. It is submitted that whatever is delineated under Rule 3, 1A, Rule 3, 1 small a, our capital lekhar obbyas ache khub. Rule 3, 1 within bracket A to 1F of the said rules of 2018, board is not required to issue any other direction pertaining to service of teaching, non-teaching staff working in non-government aided secondary/higher secondary schools. Therefore, according to respondent number 6, clarification made by the president regarding entitlement of the petitioner to receive retirement dues was not warranted under the rules. Next,
well, this is not clarification, this is a direction.
West Bengal Board of Secondary Education, and next paragraph, West Bengal Board of Secondary Education and state respondents are represented by learned advocates. Next paragraph, on perusal of the order dated 20 May 2025, issued by the president of the board, it appears that the president decided not to initiate disciplinary proceeding against the petitioner. Consequently, it was clarified that petitioner was required to receive pensionary benefits Court does not find any infirmity in the order passed by the President of the Board dated 20 May 2025, taking note of the fact that petitioner retired on superannuation on 31st December 2020, but due to pendency of the issue before the concerned authority of the board, pension case of the petitioner could not be settled. Stop. Could not be settled. Stop the as authorities decided to initiate proceeding against the petitioner. Stop. Ultimately, on consideration of the ultimately on consideration of the issue pending relating ultimately on consideration of the issue relating to service of the petitioner pending before the board, it was decided by the president that there is no requirement to issue there is no requirement to initiate disciplinary proceeding against the petitioner. Stop. Therefore, it was rightly clarified by the president of the board that there was no impediment in releasing retirement dues including pension in favor of the petitioner on compliance of necessary formalities. Stop. Next paragraph. In view of next paragraph, moreover, it needs to be recorded that decision of the president of the board dated 20 May 2025 has not been assailed by the authority of Jara High School, Paschim Medinipur. Next paragraph. In view of aforesaid discussion, state respondents, including the school authorities, including state respondents, including the respondent 6, are directed to process the pension case of the petitioner expeditiously. So, respondent number 6 is directed to forward pension papers of the petitioner after making those papers ready to the District Inspector of Schools AC Paschim Medinipur, being respondent number 5 by
Let the B.Ed document is fake. How I can
by 6 weeks from the date of communication of this order. So, on receipt of pension papers, respondent District Inspector of Schools AC Paschim Medinipur, being respondent number 5, shall settle the same by fortnight thereafter and forward it to the settle the same by fortnight thereafter and release pension payment orders at an early date, but not later than 8 weeks thereafter on compliance of necessary formalities. Next paragraph. With the aforesaid directions and observations, writ petition stands disposed of. Urgent xerox of the. Next.
Item number 30.
Day after tomorrow.
Item number 31.
The petitioner is the only teacher in the school where there is zero enrollment for year from year 2022. There is no managing committee either in the school. He's the only teacher, zero students from 2022, no managing committee so far. So I paid for an application for transfer in prescribed pro forma before the authority. There is no
managing committee in the school.
Managing committee.
Who are you?
I'm the only teacher of the school, teacher in charge. There is nobody in the school.
So what you are praying for?
Transfer, that I may be transferred to the nearby schools where there are requirement of teachers.
But the school will be there will be no school in this no teacher in the school.
There is no school at all. There is from 2022 there is no student.
No student.
No student, nothing. I'm the only teacher. I have nothing.
But that cannot be a ground for transfer.
Yes, my lord. There's a special circumstances, my lord. I have nothing to do.
Where is the ground for transfer? Under what basis you can
I have
pay?
already completed more than 5 years of service.
Simply, but what is the ground for your transfer? This is the school is not. You are getting salary regularly.
Yes, but I am paid for general transfer. I have completed more than 5 years, so I am entitled for making general transfer application.
Even if the distance ground does not permit.
Distance not permit 50 kilometers. There is no provision for distance in the rule. It only says,
But if the resultant vacancy will be 0, then
but the school is only on paper. There is no existence of that
so
school.
the court at this stage cannot consider this.
At least I have made an application. Let that be decided. What would be the fate of the school?
At this
But
stage,
kindly
the
come
court
to
cannot consider it without calling for reports from the DI.
very well. Yes. As your
Where is your application?
Yes, my lord, my first application, kindly come to page 82 onwards, in prescribed 84. Kindly see, my lord, I have written to the school authorities that there is nobody.
82 past June. This is an application for transfer.
No, no, no. I am informing that is the first formal intimation to the authority.
Where is your application
84,
for transfer?
84. 84 is the formal application. And kindly also take page 90.
And nobody is there to issue.
Nobody, no, DI can only
issue no objection.
There's nobody. That is a very critical situation I'm in. I'm going to the school. I have nothing to do. I'm coming back. There is nothing.
There is no student.
Nothing. For last 2022, there is no student. Zero enrollment school. I am there. So I have asked for the nearby schools. There are requirements.
For 22 years, there is no student in the school.
2022.
From 2022, there is no student in the school.
And I'm the only person who goes and comes.
What is the date of your application?
My lord, my date of application would be page 85.
May 2025.
10th of May 2025. And my lord, kindly also take page 90. I have also intimated
They will file a report, DI to file a report. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner made an application for transfer in prescribed pro forma. What is the date of your application?
10th of May 2025.
Where you have stated?
Page 85 bottom.
The petitioner made an application for transfer in prescribed pro forma on on 10th of May 2025. And petitioner prays for direction for consideration of the said transfer application by the concerned respondent authority. Stop. Next paragraph, it is also submitted that there is no managing committee of the school and there is no teacher, there is no student in the school from 2022. Stop. Stop the honor. And petitioner is the only teacher in the safe school. Next paragraph. District Inspector of Schools AC. Dakshin Dinajpur being respondent 5 is directed to file a report regarding the present file a report disclosing
status.
the present status of the school. Let such report be filed by 1 week after ensuing the application. Stop. List the matter under the same heading for further consideration on 6 November 2026.
Great for the lordship.
Next. What's up?
Item number 168. There was already a direction of your lordship on 30th of April 2024 in this matter.
Who is for the state?
Lordship, Mr. Sujoy Mandal appearing for the state. He is not come. I am praying not today.
Lordship can look for once one page.
2023 liquidation come after.
No, what is happening is
Is I
18
considered in their absence.
18
Last
to-
occasion also the accommodation was paid for on behalf of the petitioner. It's recorded in 4th of August. At the time of call, accommodation is paid for on behalf of the state respondents. So, however, petitioner is represented by learned advocate. Stop hearing of this writ petition stands adjourned. This the matter under the same heading.
only the DI to file a report.
Let the matter retain its position in the list.
Report of the
Already
DI.
there is a direction, Mr. Bhattacharya, upon the authority to file a report. Already by Justice Basu. I have read the order, first order. No further direction is required. Let them come, make their submission. You have changed your religion. Where is the difficulty in changing name?
That is recommended by the DI of.
Yeah, I've seen.
That still, my lord, is not being done.
Item number 169 and 170.
Pending petition page. Looking to order past the something. কালকে কিন্তু এখানে Please report. Whether the proceeding is complete.
No.
How long it will continue?
My lord, the charge sheet issued, reply given. Thereafter, my lord, the IO was appointed in 2019. Reminder given. But the IO sat tight over the matter, did nothing. Now, your lordship, again, my lord, the board has cancelled the appointment of that IO and have appointed someone fresh. That is at page 5, paragraph 5.
Yes, sir. One of them.
Whether the report has been submitted.
We have given a timeline of 7 days, but my lord, we have not received anything.
Then how long petitioner will wait?
And you also can see the nature of that. I retired on December 2020.
You cannot complete the proceedings, then say so that yes, we are not in a position to complete the proceedings. By one reason or other, if you delay the proceedings in this fashion at the cost of non-payment of pension to the petitioner, how long this will continue?
Come back, my lord. Because this is what is my instruction. Accordingly, my lord, it has been submitted.
No, but there is no change. There is no improvement in situation even after the order passed by this court. That is troubling this court.
Not sure. Your Lordship can direct for a timeline, or if not done within that period, Your Lordship, if Your Lordship desires so.
I will direct the board to pay the interest on disciplinary on the referral dues. That is. If you play with the fate of the teachers in this fashion, being a disciplinary authority, then it has to be dealt with appropriately.
Your Lordship, the board is an inquiry officers. They are not the.
We will take the
inquiry
responsibility,
board.
Ms. Bhattacharya, for this delay.
Then Your Lordship,
2020 retiree, and today we are in 2025. Who will pay the interest?
Then Your Lordship, this Pradyut Sarkar, Assistant Director of School Education, who was appointed as an inquiry officer in 2019, my lord, he did nothing. He sat.
Very well. After that, what the second inquiry officer has done?
Second inquiry officer, well, we have appointed the DI has been. The
Yes.
DI of not, he has been appointed in the month of August. Month of August.
Yes.
Selling the previous August.
Yes.
So, yeah.
Annexure page 14, annexure B.
Yes. Now, my
DI is AC not 24 Parganas has been appointed as inquiry officer.
Yes.
Now, show me that from 19th August till date, any date has been fixed for inquiry.
No, that we cannot know about that. That the DI and is between the DI. and the
Why
school.
not? You are the disciplinary
No,
authority.
we are only given after the inquiry.
You are above all. You may differ with the view to be expressed by the disciplinary authority, by the inquiry authority. So you are at the helm of everything. So you have to take the responsibility.
Lordship.
So to show me that till date DI has fixed any date for inquiry.
We have not received any information from the DI till date. We have my instruction is that we have inquired what is the latest development, though over telephone, but my lord, we have not received any nothing. This is what is there, your lord.
And petitioner will not get pension.
He must get, your lord.
Then petitioner will not get pension.
That is the reason, your lordship, the previous matter, my lord, because the petitioner was not getting. And
there is an order by the president of the board.
Yes, there was order because it was no fault of the petitioner.
So where is that? Where is the steps taken by the president?
May I submit one thing, your lordship? A time, my lord, a time, your lordship, kindly fix a time period, giving the direction upon this inquiry officer to submit a report and board to conclude the proceeding within a time period, my lord, kind. Just a time period, short time period. That I have seen, my lord. So submitting very much. Understand? I have.
Your lordship can see the
No, you have challenged it. Suspension and charge sheet you have challenged.
Charge sheet is not under challenge.
Suspension you have challenged.
charge sheet not, no, I have said, my lord, your lordship can have report.
Locus notice and charge sheet issued in connection with the recent proceedings.
I prayed for that, declaring the proceedings initiated against the petition.
Another writ petition being WPA 17945 pending where petitioner has questioned the suspension order and
That was
That-
prior to that.
suspension order and disciplinary proceeding.
That by flux of time.
So that is not before me today.
Yes, sorry, because
In the second item.
That retired to suspension is not there.
Your lordship can see the nature, if your lordship see, thinks that it should be inquired, your lordship can see the nature of the allegations. Nothing else, no document, nothing vague, page 22.
প্যারাগ্রাফ 6 এ বলা আছে প্যারাগ্রাফ 6 এ বলা আছে প্রিভিয়াস পিটিশন সম্বন্ধে পেন্ডিং ছিল
You are receiving provisional pension.
Nothing.
Provident fund you have provident fund you have received. So very well release provisional pension to the petitioner, and petitioner is entitled to receive provisional pension. Yes, provisional pension, and I will direct the newly appointed. I will direct the board, being the disciplinary authority, to complete the proceedings by 6 months.
One problem I
Clearing which necessary steps shall be taken for releasing the
Lordship.
one problem I shall say. The legality of the charge sheet I cannot challenge. The lordship must complete the procedure.
That is before me. You place it before me. What is the illegality? Yes.
The lordship, can you see?
I have seen the charge sheet.
The lordship see. Then nothing to say.
No, because if charge sheet,
Nothing else.
it is at a premature stage, Mr. Badi.
Yes.
Charge sheet cannot be interfered with unless if it is malafide or without jurisdiction. So at this stage, court will not pass any order setting aside the charge sheet.
Because of
that cannot be done.
See, Malik, is there any document that what illegality I have committed?
So that is to be carried out by the inquiry officer. But a charge sheet, if you say that there is a malafide or without jurisdiction, that cannot be done into it. Why?
Because you also can see that you are not cooperating with the office since long, and also not giving any hint to some important government projects like such and such. For which students are.
Have you given a reply to this charge sheet?
Yes, she replied.
Have you taken these points in your reply to the charge sheet?
She has replied to the charge.
That this charge sheet is bad in law.
Well, page 27 is a reply, Your Lordship. Page 27.
That is page 27. I have said that I was appointed since that I have tried my level best to hold high.
Prayer for exoneration from charges.
Yes.
Suspension. Yes.
That has not been considered at any point of time.
Yes, that will be considered in the inquiry.
The inquiry started. Is there a scope for exoneration from the charges?
Yes. If charges are not substantiated, then they will be exonerated.
That is whether Malad they have taken.
At this stage, where is the scope left open to this court to interfere with the charge sheet? Tell me.
Because of the fact, Malad, the charge sheet is a big charge.
No.
That you may say. That you may say, but at this stage, when it is not.
We were appealing to your lordship. Your lordship can be so far the pension, provisional pension is concerned, your lordship can pass a message. It is for them, it will be open to the petition, he cannot challenge. But if the court says that, madam, then I will be the.
What court says? Court will direct the authority to conclude the yes, charge sheet has been issued.
Legality of the charge sheet or legality of the disciplinary proceeding is not being adjudicated.
Yes, in the writ petition, another writ petition is there. You tell me, you demonstrate that how it is illegal.
Because of suspension.
Yes, how it is illegal.
Because suspension becomes factual, supplementary.
You have questioned the suspension as well as disciplinary
No,
proceeding.
that section is not with me, Charlie. You are not standing.
You said the impugned show cause notice to charge sheet. Yes, yes. You have challenged the charge sheet, Mr. Bari. Nanvas issued quashing and or setting aside the impugned show cause notice dated February 17, 2018, charge sheet dated 29 May 2019, and further direct the concerned responsible to recall and withdraw the impugned show cause notice. The charge sheet you have challenged.
Then my dear lordship will have to consider this petition.
Yes, you tell me. Yes,
Today I do not have that copy of the petition. I was not aware that this matter is
This copy is also not served upon me, this writ petition.
Let me dispose of all the writ petition directly.
Lordship.
Yes. Two writ petitions are considered today in presence of the learned advocates representing the parties. Stop. In one writ petition being WPA 2585 of 2024, the petitioner has prayed for releasing retirement dues including pension, as the petitioner retired on superannuation on 31st December 2020.
No, 20th December 2020.
31st December 2020. 31st December 2020 from the post of headmistress in New Barakpur Colony, just a minute. In New Barakpur Colony Girls High School, South, not 24 Parganas. Stop. In stop. Another writ petition being in another writ petition being WPA 17945 W of 20. Okay, one matter. 17945 WPA 17945 of 2019. Petitioner questioned show cause notice and charge sheet dated 29th May 2019. Which was issued against the petitioner. Stop. Taking note of the fact that in spite of issuance of charge sheet dated 29th May 2019, disciplinary proceeding was not concluded. As a result whereof petitioner was not, and as a result whereof retirement dues of the petitioner were withheld, comma, this court video order dated 17th August 2025 directed the Secretary West Bengal Board of Secondary Education within bracket for short board to file a report in the form of affidavit whether disciplinary authority was abandoned or disciplinary authority has disciplinary authority abandoned proceeding against the petitioner or not due to efflux of time. Stop. Next, pursuant to the order dated 7th August 2025, a report in the form of affidavit affirmed on 21st September 2025 is filed today on behalf of board and same is taken on record. Stop. On perusal of the
2nd
report, it
September.
appears
2nd September, Your Lordship. Affirmed on 2nd September.
21st September to গতকাল, right? 2nd September 2025. Yes, yes. 2nd September 2025 and same is taken on record. Stop. তারপর কি বলছিলাম? On perusal of the said report, it appears that disciplinary authority of the board with a memo. Now, on perusal of the report, it appears Deputy Secretary within bracket administration of the board with a memo dated 19th August 2025 appointed another person as inquiry appointed District Inspector of Schools AC North 24 Parganas as Barashat as inquiry officer and head of the institution of New Barakpur Colony Girls High School was appointed as presenting officer. Top. Learned advocate representing the petition, representing the board has prayed for some time to conclude the proceeding. In view of issuance of memo dated 19th August 2025, whereby Deputy Secretary within bracket administration appointed new inquiry officer and presenting officer for conclusion of disciplinary proceedings. Next paragraph. Having considered the report filed on behalf of the board and taking note of memo dated 19th August 2025, board is granted 6 months time from date to conclude disciplinary proceedings against the petitioner, failing which respondent authorities shall take necessary steps in accordance with law for settling pension case of the petitioner. Stop. Next paragraph. However, it is made clear that during course of inquiry, petitioner shall not pray for any adjournment, accepting the reasons which is beyond the control of the petitioner, and shall cooperate with the inquiry officer for taking the proceeding to its logical conclusion within the time fixed by this court today. Next paragraph. Subject to final result of the disciplinary proceeding, state respondents are directed to release provisional pension in favor of the petitioner within a period of 4 weeks from the date of communication of this order. Next paragraph. Since petitioner has issued, next paragraph. Petitioner in the writ petition being WPA 17945 of 2019 has questioned show cause notice dated 17 February 2018 and charge sheet dated 29 May 2019. But it is not demonstrated that whether this show cause notice and charge sheet are without jurisdiction or not. No, but it is not demonstrated. That show cause notice and charge sheets are issued by concerned authorities or are issued by the authorities who are not empowered to take such steps, and no case of malafide is made out. So, therefore, at this stage, court is not inclined to interfere with the show cause notice dated 17th February 2018 and charge sheet dated 29th May 2019. So, hence, the writ petition being WPA 17945 of 2019 is dismissed. এইটা শুরু করার আগে আগের এই প্যারাগ্রাফটা শুরু করার আগে ওইটা করে দাও, একটা লাইন অ্যাড করে দাও, উইথ দ্য অ্যাফোরসেড ডিরেকশনস এন্ড অবজারভেশন writ petition being WPA 2585 of 2024 is disposed of.
Disposal and dismiss.
Urgent xerox certificate. Next.
Item number 171.
সঞ্জয় কর্মকার ওয়ান টু ওয়ান ওয়ান দেখ না কার নাম আছে দেখ না
এই তো সুতরাং from beginning থেকে
ও লিখে রাখতে তো
Yes, report by the DI.
Lord, I am not a single subject teacher. Paragraph 7 and 8. The report. Paragraph 7, it has been stated. All of them have the similar qualification, honors PG.
Which subject petition is a teacher?
English is a teacher of English. There are 3 total English teachers with honors PG. 2 are of normal section, petitioner of the HS section. 3 of them have the master's degree. So technically, my lord, I'm not a single subject teacher.
What is the name of the petitioner in the staff pattern?
The lordship will find my name as the HS section, Sanjay Kormokar.
Oh, HS section.
HS section, kindly find Sanjay Kormokar. I have the better copies, if your lordship, if it is not legible enough.
No,
Yes.
tell me normal section, then HS section.
HS section, my lord, kindly see left hand side, Sanjay Kormokar. MA B.Ed, subject English, right hand side, column. And my lord, kindly take the normal section. This at the top, Nirupam Pramanik Obhijit Haldar. 4th name, MA B.Ed, English, MA DLEd, English. Master's degree in English. 3 of them have the master's degree. So I'm in the school, I'm not the single subject.
English.
And 2 of them are the paper setters and examiners of HS, English. That document I have.
That this Anupam Pramanik and Obhijit Haldar.
Nirupam Pramanik and Obhijit Haldar.
Nirupam Pramanik and Obhijit Haldar.
Yes, they are the paper setters of the HS section of English. These are the documents I have found.
But pupil teacher ratio does not permit.
But that is not the ground of rejection.
63.15 is 63:1 is the pupil teacher ratio.
Yes, but
How it can be
that is
permitted?
not the ground of rejection. Page 86, kindly see. That was never the ground of rejection. Page 86.
I have decided in other matters
Yes,
that pupil teacher ratio does not permit.
Your Lordship was
And this is
also,
not a transfer on medical ground.
it's a general ground transfer.
General
But
ground
that is
transfer.
not the ground on which I was rejected.
Sure.
And my Lord, your Lordship also held
In
that
terms of
teachers are there.
dated 2nd May 2025, a report is filed by the District Institute of Schools, AC South 24 Parganas, or a report is prepared by the District Institute of Schools, AC South 24 Parganas, dated 12 June 2025, and same is filed today by the learned advocate representing the state performance and taken on record. So, on perusal, next paragraph. On perusal of the report, it appears on perusal of the report and the staff pattern annexed to the said report, it appears that it is true petitioner is not a single teacher in English in the school in question. There are other assistant teachers in English working in normal section, namely Nirupam, Pramanik, and Obhijit Haldar. Stop. Both the aforesaid assistant teachers in English are having requisite educational qualifications for taking classes in higher secondary section. Therefore, petitioner, though is a sole teacher of English in higher secondary section, should not be adjudged as a sole as a single teacher in the in English in the school due to presence of aforesaid two teachers of English in normal section having requisite qualification to take classes in higher secondary section. Next paragraph. But fact remains, there are 1200. But the fact remains, present roll strength of the school in question is 1200, whereas 19 teachers are working. Comma. Pupil teacher ratio is found to be poor, which does not permit a teacher of the school to be transferred on the ground of distance in between the present school of the petitioner and the residence of the teacher. Next paragraph. Therefore, at this stage, no relief can be granted to the petitioner. Stop. However, if pupil teacher ratio of the school in question is improved, petitioner shall be at leave to apply for transfer in accordance with law. Great. Next.
Item number 172.
My lord, my senior advocate Santopal is appearing in behalf of school. He is in another courtroom. I am appealing in short passover. My lord.
My lord, kindly consider, my lord.
Next matter. What consider, sir? Other side is praying for time. Yes.
Item number 173.
Therefore, the petitioner.
I could not in a position to, my
What is the urgency in the matter?
My lord, I could not in a position to extend, my lord, my head examiner, my lord, application, my lord, and my lord, kindly consider.
Next matter.
I am a PhD in physics.
Yes. There is no urgency as such.
Day after tomorrow, my lord.
No. Yes, please call the next matter, not today. If before vacation these matters are taken up, again it will be taken up. I am not making any comment. Yes.
Item number 173.
173.
My lord, in this matter, my lord had directed the state
Who is for the petitioner? Record an order. At the time of call, no one appears for the petitioner and no accommodation is paid for. However, state respondents, West Bengal Board of Secondary Education and West Bengal Central School Service Commission are represented by learned advocates. Next paragraph. List the matter under the heading motion in the monthly combined list of December 2025.
Will it be my lord's pleasure
Next,
to
next,
keep a
next,
copy of
next.
the instruction?
Item number 174.
Ready, you want to file a report?
Yes, my lord.
Report on now.
It's a matter of
Report filed on behalf of the state respondents is taken on record.
174.
Item number 174.
It is a matter, my lord, where the question of, my lord, the selection process of 2016 for upper primary hearing is already over before Justice Rai Chattopadhyay. We are waiting for the judgment. My knowledge friend was with me, against me. Lordship, take it up after the holidays, my lord. I think in the meantime, judgment may come.
But upper primary, it is 90% relating to.
Yes, yes. Well, this matter is slightly different. This is more with regard to the teacher eligibility test. Let it simply be sent after the vacation.
At the time of call, learned advocates representing the petitioner and West Bengal Central School Service Commission have prayed for accommodation.
I am for listed by.
Stop. Give your appearance. Stop. Next paragraph. List the matter under the heading. List the matter under the heading motion in the monthly combined list of December 2025.
Grateful.
Give your appearance.
Item number 175.
Yes, yes.
There was a direction to file a report.
What you have stated in the report. Just in case. Not a single teacher, but pupil teacher ratio does not permit. 1525 students against 25 teachers. Pupil teacher ratio is 61.1. 61:1. Marginal, not marginal. 40:1 is the ratio.
That is stated. That is already stated.
And the situation in higher secondary section is worse. That is 235 students against 3 teachers.
But I'm this teacher of normal, so but you not fasting. Situation to arise.
Yes, yes.
Well, the 6(2) subclause C, not commensurate with the role strength and PD.
In terms of the order dated 3rd April 2025, a report of the District Inspector of Schools AC South 24 Parganas dated 22nd April 2025 is filed by the learned senior advocate representing the state respondents. And same is taken on read. Next slide. On perusal of the report, it appears that petitioner is a teacher of Sanskrit in normal section, whereas another teacher of Sanskrit in higher secondary section in the same school is working. Therefore, petitioner ought not to be considered as a single teacher in Sanskrit in the said school. But while considering the prayer of the petitioner for transfer, court finds that court finds roll strength of the school in question is 1525, whereas 25 teachers, including petitioner, are working. Stop. Pupil teacher ratio is 61:1, which is much beyond prescribed limit of 40:1. Next paragraph. Petitioner made a prayer for transfer on the ground of distance in between the present school of the petitioner and his place of residence. So, therefore, court finds pupil teacher ratio is a relevant consideration while taking decision on such transfer application of the petition. Stop. Hence, no relief can be granted to the petitioner. Stop. Writ petition stands dismissed. However, next paragraph. However, this order shall not preclude the petitioner to apply for transfer if pupil teacher ratio is improved. Urgent xerox certificate. No. How can I do? I am not granting your prayer.
Item number 176.
Yes.
The transfer application on self-medical ground is pending before the commission.
Just a minute.
Status is page 1919.
Yes, report.
We get CMOH to supply the report, but he has not been. This is my.
Where is Mr. Dey? Where is Mr. Jawaharlal Dey?
He is engaged. But we did not receive any copy of the application.
আমি দিয়ে দিয়েছি দিদি আমি দিয়ে দিই সঙ্গে সঙ্গে
Have you not served copy?
Yes, immediately I have served it. I am not any pending.
Yes, so where is the medical report?
That they have not supplied to the DI.
Then how DI could forward it? Where is the status?
Page 19.
Yes, page 19. Yes, then if it is not supplied to the DI, then how DI could forward it to the commission?
On 7th May.
Don't be too clever before this court. If DI forwarded it, then your DI will be in soup. I will direct the DI to remain present, leaving aside all other work.
No, no, say
DI forwarded it on 20th October 2022.
but medical.
How
report is-
DI could do this without seeing the medical report? Can the DI say that it was not forwarded to him? Don't make absurd submission. If it is a case that the medical officer did not forward the medical report to DI, then DI will simply wait for medical report. But how DI could forward the transfer application without seeing the medical report?
I will take instruction.
The order was passed on 30th April 2025. How long petitioner will wait? Let a cost be paid to the petitioner for a 7 days after vacation, 70,000 rupees.
I am not in the register. The instruction is happy.
How your DI can make this application? How your DI can file this report? Show me the report. That it was not forwarded to DI.
I would again request Miller.
No, he is not making the correct submission. He is saying that the report is not available with the record maintained in the office of the DI. That's why a letter was sent on 7th May 2025 to the Chief Medical Officer of Health Bankura for furnishing the report or supplying a copy of the report if same is available. But no response from the Chief
In
Medical.
this situation, since application is
Let a fresh
fresh
medical inspection be made. Make an appropriate submission.
Kindly direct them to supply copy of the report.
And this is an old application of 24th of August 2022. 24th of August 2022 application. And you file the writ petition in 2025. Issue. In terms of the order dated 30th April 2025, a report of the District Inspector of Schools AC, Bakura. Dated, what is the date of this report? Not readable, 14th May 2025. Dated 14th May 2025. Is filed today and same is taken on. Stop. On perusal of the said, next paragraph, on perusal of the said report, it appears that medical report which was furnished in connection with online transfer application of the petitioner dated 24th August 2022 was not available on record. As a result whereof, District Inspector of Schools, AC Bakura being respondent number 5, requested Chief Medical Officer of Health, Bakura, with a memo dated 7th May 2025, to supply a copy of the report if same is available on record. Or if same is available, stop. On record ta korona, stop. However, it is stated in the report it is stated in the said report that in response to the memo dated 17th May 2025, concerned Chief Medical Officer of Health not furnish copy of the report. Next paragraph. Learned advocate representing the petitioner submits, since application for transfer on self-medical ground, since application for transfer on medical ground was made by the petitioner more than 3 years back on 24th August 2022, she may be examined again by the medical expert for ascertaining her present health condition. Next paragraph. West Bengal Central School Service Commission and Board are represented by learned advocates, and it is submitted on behalf of on their behalf that due to efflux of time, health condition of the petitioner may have improved due to Stop. Next paragraph. Having considered the submissions made on behalf of the parties and taking note of the report dated 14th May 2025, respondent number 5 is directed to obtain medical report on respondent number 5 is directed to obtain report on medical examination of the petitioner from the concerned Chief Medical Officer of Health, Bakura/Medical Board, by 4 weeks from the date of communication of this. In the medical report, TMOH/Medical Board is required to opine considering present health condition of the petitioner whether she is required to avoid long distance journey or not. Stop. If medical report justifies transfer of the petitioner, transfer application along with medical report shall be forwarded by the respondent number 5 to the Chairman, West Bengal Central School Service Commission, being respondent number 4, by fortnight thereafter. Next paragraph. On receipt of transfer application, respondent number 4 shall decide the same in accordance with law within a period of 6 weeks from the date of communication of this order, and same shall be communicated to the petitioner by fortnight thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject the transfer application of the petitioner. Stop. Writ petitions disposed of urgent xerox certificate.
The date of receipt of the report from the DI. School Service Commission is directed to consider within 4 weeks from the date of.
Fortnight. On receipt of transfer application and medical report.
Yes, madam.
Acha, put the on receipt of transfer application and medical report. Yes, yes, that I have recorded. Next matter.
Item number 177.
I'm for the petitioner, my lord. My lord, in pursuance to the my lord's last order, petitioner joined the school. So order dated 30th of April 2025, my lord.
জয়েন করে 7 তারিখ করে জয়েন করবো না বলার পরেই জয়েন করছি 7-6 বোধ হয় 7-6 সম্ভবত Yes.
My lord, I have joined the school.
Already you have joined. In terms of this order, administrator has permitted you to join.
Yes, ma'am. Yes.
When you have joined?
My lord, the one communications with me.
Yes.
May I just my lord, the date is not indicating here.
That's the Yes, then this DI has DI forwarded this memo, issued this memo to the administrator.
Yes, sir.
Then in pursuance to this memo, administrator permitted you. When you have resumed duty?
My lord, after the vacation, I have not come with the exact date. Only after the summer vacation, which I have instructed.
So your grievance is redressed. Issue.
One last development, my lord, though this is not a part of this writ petition, that after the join, I have been removed from the post. But this is not the
from the post of teacher in charge.
Yes, ma'am. But
you are working as an assistant teacher.
Yes, right now. Because
that is not an issue
in this writ petition.
Issue was that you are not being permitted to join the school.
And I have also not been
after 17 January 2020.
Yes,
ma'am. Matter is taken up for consideration in presence of the learned advocate representing the petitioner, and you are for the state. And the state
led by Mr. Jawaharlal.
Stop. Next paragraph. Learned advocate representing the petitioner submits that pursuant to the order dated 30th April 2025, a memo dated 23rd May 2025 was issued by the District Inspector of Schools AC, close bracket South 24 Parganas, thereby requesting the administrator of Doyapur PC Sen High School, South 24 Parganas to allow the petitioner to resume duty. Stop. Copy of the memo dated 23rd May 2025 issued by the District Inspector of Schools AC South 24 Parganas is placed before this court and same is taken off. Next part. Learned advocate representing the petitioner further submits that in view of resumption of duty by the petitioner, grievance of the petitioner stands replaced. Next paragraph. Having considered the submission made on behalf of the petitioner and taking note of the fact that petitioner was permitted to resume duty after the order was passed by this court on 30th April 2025, writ petition stands disposed of. There shall be no orders to cost or the xerox.
Grateful.
Next.
Item number 178.
And for this proceeding.
I have for the state.
Yes.
School has already forwarded to the DI conduct the medical examination. This is the
When medical examination was conducted?
report will not be the exact date I cannot say. This is my specific.
So are you aware of who is for the DI?
Right.
Whether you have any instruction or you have any instruction
No,
that
no,
what is the report, what is the medical report, whether medical report justifies your transfer or not, supports your transfer application or not?
Medically examined, but report, possibly report, and it is a
Well,
internal.
let me dispose it of observing that if medical report justifies petitioner's transfer,
My only
then it
instruction
will be
is this.
forwarded to the
Yes, yes,
commission for taking
She
decision.
is the only teacher in bioscience. That is the instruction.
That is not a ground in case of medical
Certainly.
transfer on medical ground.
No, no.
School issued the NOC.
And secondly, my lord, she has not submitted any medical paper, medical report. করেছে আলাদা করেছে না আগে ছিল না
You are for the school authority.
Yes.
Issue. Affidavit of service. Today you are filing affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. It is submitted by the learned advocates representing the school of representing the petitioner and school authority that after order was passed on 16th April 2025 by this court, school authority issued no objection in favor of no objection on transfer application of the petitioner. When no objection was issued?
24th April 2020.
24th April 2025. On 24th April 2025, and same was for and transfer application was forwarded to the District Inspector of Schools, AC, Howrah, being respondent number 5 for taking further steps. So next paragraph, it is submitted by on behalf of the petitioner and the state respondents that petitioner was medically examined by the medical expert 2 weeks back, few days back. However, medical report is not made available to the petitioner. Stop. Next paragraph. As the petitioner has already been medically examined by the concerned medical authority, or as the petitioner has already been examined medically has already been examined by the concerned medical authority, comma, respondent number 5 is directed to forward transfer application along with medical report to the chairman West Bengal Central School Service Commission being respondent number 4. If medical report justifies transfer of the petition. Stop. Sentence টা পড়ো। টাইমটা বলে দিতে হবে।
অনলাইনে অনলাইনে যাবো তবে
by fortnight or by না তার আগে করো by 4 weeks from the date of communication of this order if medical report justifies যেটা বললাম transfer of the petition. Next paragraph. In the event transfer application along with medical report are forwarded to the respondent number 4, same shall be decided by the said respondent number 4 by 4 weeks thereafter, and decision to be communicated to the petitioner by 10 days. Next one. It is made clear that suspension of portal shall not be a ground to reject transfer application of the petitioner. Stop. Read petition stands disposed of urgently. Next.
Item number 179.
I am appearing on behalf of the state, Your Lordship. Your Lordship, as per your last order for submission of report on part of the DI, report is here, Your Lordship. But the same thing is like the last case, suspension of the portal till 31st December. In paragraph number 3 and 4.
Just a minute.
Okay, okay.
Which paragraph you have disclosed the reason for not forwarding transfer
Your Lordship, paragraph number 3 and 4 of the report.
only suspension of portal.
It is pending distance down transfer application pending before the GI. The school already issued the page number 7.
Issue. In terms of the order dated 16th April 2025, District Inspector of Schools AC Purbo Medinipur being respondent number
5.
Has prepared a report dated 21st April 2025 and same is filed today and taken on record. Next paragraph. On perusal of the report dated 21st April 2025, it appears that transfer application of the petitioner dated 21st September 2022 was not forwarded to the West Bengal Central School Service Commission due to suspension of Uchotsi portal. Next paragraph. It is already decided by this court in other matters that suspension of portal cannot take away the right of the petition, right of the applicant teacher seeking transfer, as such right is conferred by statutory provisions. Next paragraph. Hence, respondent number 5 is directed to forward transfer application of the petitioner to the West Bengal, to petitioner, to the chairman, West Bengal Central School Service Commission, being respondent number 4, by 3 weeks from the date of communication of this order. So, on receipt of transfer application, respondent number 4 shall decide the same in accordance with law within by 4 weeks thereafter, and decision to be communicated to the petitioner by fortnight thereafter. Next paragraph. It is made clear the suspension of portal shall not be a ground to reject transfer application. Stop. Writ petition stands disposed of. Obliged. Next.
Item number 180.
School, madam.
Therefore, the school,
School, madam.
who is for the state,
Yes, sir.
yes, have you issued no objection in favor of the school teacher?
My lord, there are two things, my lord. One is, my lord, the pro forma that the petitioner has filled up, my lord. There, the petitioner have stated that she does not have a child pertaining to 12 plus age, but
She does not have?
she does not have a child whose age is below 10 years. But actually, she has stated that she has child below 10 years, but that is not the current fact, my lord. My lord, may come to page number 38, my lord. Point numbers 7, 4, and 5, my lord. Children in case of female below 10 years of age, my lord. Page number 38 of the petition, my lord.
Yes.
Yes, my lord. Point number 7, 4, my lord. Children in case of female below 10 years of age. She have ticked yes, my lord. But
Yes.
But my lord, in a
She does not have a child below 10 years.
She has two child whose age is 12 years plus, my lord.
Yes.
We can get this from this document, my lord. She had on one occasion, may I place this, my lord? On one occasion, she had applied for a child leave, my lord. From that, we can get that she has
The age of the child.
the age of the child, my lord.
So therefore, she has declared under clause 7(4)
Yes, my lord.
that she has a child below 10 years. That is not the correct position.
That is one point, my lord. And second point, my lord, is that she had taken a personal loan from the school cooperative society, my lord, of 3 lakhs, my lord. However, she have been paying it back, my lord. Currently, the amount comes to an amount of 1,51,604, my lord.
Still due.
Still due, my lord. This is the two facts that we are objecting to this, my lord. And
yes. Yes.
My lord, in that point, my lord, I'm paying.
What do you mean?
My lord, so far loan is concerned, my lord, loan is concerned, I have to pay. There is no doubt it is in public.
Without paying loan, you
No,
want
it is
to leave the
public money,
school.
my lord. I shall talk, my lord. I shall talk with my client. It is the public money. It is my duty to.
No, but at the time of filing the writ petition, have you disclosed it? That is the most important thing.
My lord, subject to correction.
Where is the disclosure of
My lord,
these
subject to
these
correction.
particulars?
No, my lord, subject to correction, my lord. This loan generally disbursed from the salary account. If the salary account transferred, automatically loan. It is I have do several matter in the.
No. Where is the disclosure in your that there is a standing loan account in the name of the petitioner and the due amount is such? Where is the statement made?
No.
And there is a misstatement, page 38 under clause 7(4), that the petitioner has a child below 10 years.
Petition I am paying only. Then my lord, we withdraw.
File your affidavits, opposition and reply. Issue. Affidavit of service filed. Today you are filing affidavit. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. School authority is represented by learned advocate who has opposed the prayer of the petitioner for transfer on medical ground.
On medical ground.
On medical ground.
Cardiac.
Since petitioner has made a statement in the transfer application made in prescribed pro forma that the petitioner is having a child below 10 years. So according to the school authority, this was a wrong statement made by the petitioner, and petitioner on the date of submitting transfer application did not have a child below 10 years. Next paragraph. Moreover, it is also submitted that petitioner took a cooperative loan
Cooperative loan, my lord.
cooperative loan through the said school authority, and the part of the loan amount and the part of the principal and interest is still remaining due. Next paragraph. In view of the submissions made on behalf of the school authority, issue needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks after ensuing puja vacation. Stop affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for extending amendments.
My lord, may I take back the documents, my lord?
Disclose it by filing affidavit.
Grateful, my lord.
Item number 181.
Who is appearing for the state? Who is not represented?
And I had served upon this school also.
Last one, Amitabh Broto Rai and Shivashish Banerjee. The state. Serve notice and come there.
This one was returned in your 10%.
5-6.
After the application, the 8 teachers have
Who
joined.
is not represented?
8 teachers have joined. That is why the
But based on your submission, court cannot pass any order. Court has to hear the other side.
I have it on record.
Now today, since the state is not represented and school is not represented, you have served notice upon the school, but school is not represented. Serve notice upon the state to appear. Because I will direct in that event to upon the DI to submit a report. Issue. Affidavit service filed on behalf of the petitioner is taken on record. In spite of service of notice, authorities of Palla KPC High School, Palla KPC HS School, North 24 Parganas being respondent number 7 and 8 are not represented. Next paragraph. Learned advocate for the petitioner is directed to serve notice of the learned advocate representing the state respondents, enclosing copy of this order by 26 September 2025. Stop. List the matter under the same heading for further honor. Let the matter retain its position in the list.
After serving,
No, I do not generally pass any order directing the DI to file report in absence of the representation on behalf of the state. Otherwise, on the next date, nobody will be there to take care of my direction.
Reopening date.
It will retain its position. You submit a report in the survey notice upon the learned advocate. Amitabh Burto Rai, and now he's a government pleader. And his junior is there. Next.
Item number 182.
In this matter, I am for the state. As the lordship direction last occasion to file the report by the DI. But just now I have received information to mobile from the DI. 2 teachers are there. File is not ready, my lord.
File is?
Report is not ready, but
So you
instruction
need
is there.
extension of time to file report.
Maybe.
Maybe.
Oh, sorry, my lord. Otherwise, my lord, I have an instruction from the DI.
Affidavit of service filed on behalf of the petitioner is taken on record. Next, learned advocate representing the state respondents has prayed for extension of time to file report in terms of the order dated 17th April 2025.
Can you see the order, but not?
Time to file report stands extended. Yes.
Report is not correct.
Time to file report stands extended by 7 days. By 7 days after puja vacation, after ensuing puja vacation, stop. List the matter under the same heading in the supplementary list on 17th November 2020. Next.
Item number 183.
Petitioner made an application on special.
Other side.
There is a direction to file report
By the DI.
DI. And this
Tausif Ahmed Khan and Sucheta Banerjee.
there is a
DI
direction.
was transfer matter. DI was directed to file any.
So on special ground, she's a divorcee, single mother. On special ground, she made transfer application. School did not forward it. Your lordship directed me to
Have a notice upon the learned advocate representing the state.
only fixes it before this side.
Issue.
The affidavit of service, fresh affidavit of
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph.
But there is a development.
You are for the state.
No, my lord, I am in it.
Don't appear.
There is a development.
Then you have to file a report.
There is a
Take your seat.
there is a development after filing the writ petition. The DI says that it has not been made through the proper channel, though I have made, and temporary suspension of portal. This after filing the writ petition, this has come.
Well, but I want it from through the affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. State respondents are not represented by learned advocate. However, West Bengal Central School Service Commission is represented today. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondents by 26 September 2025. Stop. List the matter under the same heading on 29th October 2020.
November.
29th October. November, you have difficulty.
October, I have some last few days, my lord, I have some difficulties.
6th of November.
I'm grateful to lordship.
Next.
Lordship, I beg to appear for the petitioner in item number 184, Lordship. Am I audible, my lord?
Item number 184.
Lordship, I am for the petitioner in item number 184, Lordship.
Yes.
This court directed me to file supplementary affidavit. My learned friend is there to hand over the supplementary affidavit, Lordship. Miss Ananya Shau is there, Lordship.
Where is your learned friend? Nobody.
Ananya Shau.
Yes, Mr. Lyrie, you are there. Who is your learned friend?
Ananya Shau.
He's not there. Well, not today. Not today. You
Okay,
take,
Lordship.
talk to your junior.
Lordship.
Next. Yes, fine. Not today.